Madam, may I have your lordship's leave? And I am seeking leave to move an urgent motion next week, any day. Urgency is this, that the assistant teacher in English, he has been prevented from attending the school. He has been, my lord, assaulted. Since my lord,
Why?
my lord, actually, he has pointed out about the illegality committed by the school authority. That is the whole difficulty. And since my lord, December, my lord, he is not being allowed to attend.
Since December, we are in February. What were you doing till in the month of January?
My lord, if I be not able to, my lord, the join, my lord, then entire period will be unauthorized.
Yes. I can understand it will be unauthorized. You file it in the department and give the number.
Yes.
10th it will appear next
10th?
Tuesday.
Next Tuesday. All right.
File it in the department.
Yes.
Milord, may I permitted to Milord crave leave to file this application and to move this application this week, Milord. The urgency is that, Milord, the petitioner, Milord, participated in the Milord second LST, Milord, conducted by the Milord Central School Service Commission. Milord, initially 10 marks was awarded, Milord, for experience, Milord. Subsequently, Milord, within few hours, Milord, that 10 marks was deducted, Milord.
Yes.
And
So,
Milord, while including that 10 marks, Milord, the petitioner's candidature was, Milord, shifted to, Milord, waiting list, Milord.
yeah, obviously, 10 marks makes a
10
lot
marks,
of difference.
Milord. And that 10 marks was initially awarded, Milord, in conformity with the Milord Schedule 2 of the Milord existing notification, Milord.
File it in the department. Several matters pending with 10 marks. So nothing is going to happen. You file it in the department.
Lordship.
Yes.
May I have my lords kindly to mention a restoration application, my lord. This is an order.
What?
My lord, this is an order which was passed by your ladyship in the previous determination in October 2025. My lord, the writ petition was dismissed for default. Lord, I am humbly seeking restoration, my lord. I filed an application that would come before your ladyship. I tried mentioning before the honorable judge taking up determination. Lord, that can is pending. Lord, perhaps your ladyship has to take that up for recalling of the order, for dismissal of default. Lord, the monthly list was being called.
If it is recalling on merits, then it is something else. But for restoration, the bench having determination can take it up. Check up the noting in the list. Combined list noting is there.
Lord,
Restoration applications will be taken up by the bench having determination. Right? You check up.
Grateful,
My lord, seeking for upgradation, my lord, second SLST matter. Yesterday, my lord, I failed to lay down my faith in the courtroom, my lord. That is the only.
I do not accept your submission.
My lord.
Because check up the YouTube recording.
My lord, I was there, my lord.
Thereafter also
thereafter,
have
my lord, my lord, by that.
Sorry, I am sorry.
My lord, there is certain urgency, my lord.
May I permit to mention for one correction, my lord? The name of the petitioner, my lord.
Wrongly recorded.
Yes, my lord.
Lordship, may I permit it to
Yes.
mention upgrade motion, production of answer script.
You want?
Production of answer script.
Production of answer script. Which examination?
Higher secondary examination.
Which year?
2024. Till now, I don't know about my result.
24, you are mentioning in 26. Higher secondary is going to start.
List item number 1379.
Right. You are mentioning for upgradation.
Matter is appearing in the February monthly list 1370.
Sorry.
Milord, may I file and come back, Milord? The urgency is that, Milord, if in the meantime, Milord, the Milord filled up, Milord.
File it in the department. I'll see what is to be done. Call the list, please.
Milord, I beg to appear for the petitioner. Milord, this is a contempt appearing at my behest against an order passed by your lordship dated 10th of April. Milord, I'll tell your lordship what has happened here.
Show me the order, please.
Yes, Milord. 59. Milord, kindly take page 59.
The bank was merely directed to take steps for properly maintaining the records and data of the petitioner.
Milord, if I may just.
And they ensures that the petitioner is delinquent. What has happened?
Milord, I'll tell your lordship. What has happened here is that I got a call from ICICI Bank telling me that I am a guarantor to a particular loan. and my personal details were
Don't
remain.
tell me all those things.
No,
Tell
just a brief background. So
nothing. Paragraph number 3, the bank was directed to take steps in a particular manner. Has this been done or not?
no, it's not. I
Some
made over a
notice.
communication, my lords.
Very well. Please come. Notice service করতে বলেছেন। It is returnable on the 2nd of March.
I'm grateful, my lord.
Item number 2.
Corporation was supposed to apprise your lordship.
And I have filed an appeal, my lord. Appeal papers have already been served upon the petitioner as well as the KMC, my lord. It is scheduled to appear on 10th of February, my lord.
In the meantime, corporation was also supposed to take a decision. A hearing
I have
took
challenged
place.
the order of 17th November, my lord.
Very order of
17th November, from which the direction upon the KMC was given.
in this matter. In this matter.
Yes, yes.
17th November.
Yes, 17th November 2025 order.
That was the
That is
direction.
the order was passed in the read petition, WPO 786, my lord. That is item number 3, I think.
But directing corporation to take a decision.
All right.
And pursuant thereto, corporation held hearing on 2 occasions. My learned.
Do you have anything to show?
Well, the person concerned, the executive engineer concerned, his family is in great trouble. He has gone to the other one for hospitalization. Therefore, file has been returned to them and no further information has been received. I am told that the matter has been sent to the laudable and possibly certain of the legal issues are involved. Once the matter was placed, as my learned said, that for hearing regarding that issue, but further information could not be ascertained because the person in charge, he could not give the current information.
If my lord kindly makes a time frame for them to take a decision, for the corporation to take a decision. This much I was humbly beseeching.
See, the time period within which the corporation ought to have acted expired long back.
One part of the order, because your lordship, the writ petition is challenging the order on 408. But that is to be considered by your lordship. But in the meantime, your lordship directed for consideration. These goes to the other aspects because the 408 your lordship has recorded in the earlier, in one part of the order on earlier occasion, that this is not required hearing. That is the reason possibly matter has been sent to after taking the issue for consideration.
Please come. Give me the number,
Appeal
APOT number. Learned advocate representing. Who are you representing?
Respondent number 7 in the read petition and the contempt petition. and the
Name.
petition.
What is the name of your
Abhishek
party?
Mishra.
Abhishek Mishra.
The contempt petition was taken out by me.
There are 2
Alright.
contempt petitions,
Abhishek
one by me,
Mishra.
one by me.
Submits upon instruction that an appeal has been preferred.
APOT 18 of 2026.
18.
18.
18.
Being APOT 18 of 2026, challenging the order passed by the court on 17th November 2025 in WPO 786 of 2024. Within bracket, Messrs. Shri Shyam Projects Private Limited and another versus Kolkata Municipal Corporation and others. Stop. It has been submitted that the appeal is due to be taken up for consideration by the Honorable Division Bench shortly. Stop next. In view of such submission, let the contempt application be posted for further hearing on 10th March 2020.
Lord, may there be direction upon municipal authorities to come back with an order on 10th of March.
An updated report by the corporation shall be filed on the urgent date.
Grateful to your lordship. Great.
Ekdom.
Your lordship directed the contempt matter to appear on 10th of March. And so far as this read petition against in respect of which appeal has been preferred,
All were appearing together.
that the read
Appeal
petition.
also appear on 10th of March.
Read petition also.
Grateful.
Your privilege.
Number 5. 5 I appeal.
I am for the school authority.
Yes.
As per the direction of this honorable court, I am filing affidavit in opposition.
Where is the state?
Lordship, item number 6, I am appearing behalf the state, Lordship.
In the original side?
Yes, Lordship, original side, Lordship.
5, 6, 7 are
Same,
same.
Similar matters. Six
similar
were there.
matters,
5. Mr. Boisho, not in item 5?
No, Lordship, I am not in the 5, Lord, I am not 6.
That the affidavit has been served on me by the school. So, my lord, I don't need to file any reply because this is absolute point of law. My lord, it's a case where the petitioner has
Tell me one thing. 6 is also same.
same.
Let 6 be heard first because the state is
Yes,
also here and
no,
the
no
school
problem,
is
no
here.
6
And then we'll see what is to be done with 5.
6
Yes,
টা কি নাম আছে?
Six ki naam ache?
Sanjay Kumar Singh.
Very good.
সঞ্জয় কুমার সিং।
Opposition file in Sanjay also?
Hmm.
Give your
All three, all
opposition.
But kindly have a look too. It is taking up.
Sanjay Kumar Singh, my lord, affidavit in opposition affirmed in the year 2022. But that has been served also upon the petitioner. But the original oppositions, I do not find, my lord, whether it has been recorded or not. Pursuant to lordship's directions, I made a copy of that has been affirmed also.
All right.
Very well, no issue.
Hmm.
But my case is in this petition is very limited. But since 2005, in the DA getting school, I'm working as an assistant teacher in English, unapproved. Now, in 2015, this court directed the DI to consider the case of the petitioner for approval. The reasoned order was passed at page 51. Your lordship will find the reasoned order. 17 petitioners were heard by the DI, in which item number 1, serial number 1 is of the
Petitioner.
Present petitioner.
Hmm.
The DI has rejected the prayer of the approval. Now, the moment the prayer of the petitioner was rejected for approval on 14th of January 2016, page 53, can you have a look? 6th of November 2020, the secretary has issued an order of termination. Terminating me from service.
Yes.
Now, questioning this termination, I have come before your lordship. Now, the affidavit in opposition filed by the school, the moot point they have taken is that it's a DA getting school. The unapproved teachers, they don't have any locus standi to approach the court, questioning the decision of the termination passed by the management, because the management is a private management. But this is not at all correct.
You are challenging page 53?
Yes.
Not the order of the DI.
No. Because in the order of the DI has mentioned certain points, which the school cannot fulfill. So, my question of approval comes later on when the student strength will increase. Now, here the case is that the affidavit filed by the school has a special point. If your lordship can have a look to page 7 of the affidavit in opposition.
Yes.
Serial number 7, VII. The authority of the DA getting school, like Sri Vishuddhanand, is not granted by, not governed by any statutory provision of law and not receiving any public fund. Only approved teachers and non-teaching staffs of the said DA getting schools are allowed to avail DRNS allowance from state. Therefore, the dispute raised in the instant writ petition arises from a contract of personal service, and as such, the termination of service of the petitioner is not required to be followed by any statutory law of the state. Then, the continuation of service of an unapproved teacher condition of service of an unapproved teacher of delegating school is not governed by any statutory provision of the state, and no rule had yet been framed by the state for procedure to be followed for removal or termination of service of the unapproved teacher staff of delegating school. The authority of the board has also intimated in respect of such issue of removal to the extent that the matter related to removal of unapproved staff is not under the jurisdiction of the board, and the managing committee of the school is competent enough to take the decision on this matter. Copy of the intimation of the board is annexed. Now, the board has mentioned page 22 that the removal of these unapproved teachers, the board has no power, no authority. Absolutely correct. Now, to that extent, but I would like to place one order of this court of Justice Shogata Bhattacharya, where in a delegating school, the same point was under the same point was discussed. This unapproved teacher, Priya Chatterjee, was terminated from service. But the decision of the school was questioned by the said petitioner in Priya Chatterjee's case, and Justice Shogata Bhattacharya has interfered with the order of termination. The school preferred an appeal against Justice Bhattacharya's order.
Appeal where?
Before the division bench.
All right.
And the division bench did not interfere.
All right.
But here is a very interesting part. In the affidavit in opposition, the school has come up with a plea that the management is a private management because it doesn't get any fund from the government, and the teachers are unapproved. The second part is correct. Teachers are unapproved. But whether the management is a private management, all the rules of 1969 management rules are being followed by this management, and this management has been approved. The election of the managing committee has been approved by the board. Kindly have a look to the management rules once, but for my satisfaction.
Correct.
Yes.
Page 178. Let the rule 28.8. Kindly have a look to page rule 28.8, because Justice Bhattacharya has categorically mentioned rule 28.8 in Priya Chatterjee's case, which has not been interfered by the division bench. But the rule says,
No, you read out, I can follow it.
Both in aided and unaided institutions, the committee shall have the power, subject to the prior approval of the board, to remove or dismiss permanent or temporary teachers and other employees. So, prior to the approval of board is required. Where is the approval? Number after dismissing me, they have intimated it to the board. The rule 28.8 has not been followed at all, which Justice Bhattacharya has specifically pointed out in his lordship's judgment. And that is why his lordship has granted a stay. And if your lordship can have a look to the provision for which I want to request your lordship to see the formation of the managing committee and role of the board. Unless there is a specific approval of the executive committee of the board extending the statutory term of the managing committee, every member of such managing committee shall have to vacate the so and so. Then the head of the institution, or in the absence of the head of the institution, the other members of the teaching staff temporarily assigned to discharge the duty of the head of the institution shall submit to the board 3 copies of the report on constitution or reconstitution of the managing committee after it has assumed charge as per the specimen form 4 MC through the District Inspector of School Secondary Education and the Director of School Education West Bengal with an advance copy to the board within 7 days. So the approval of the board to the managing committee is required. So the managing committee is not a private authority. Next, the head of the institution, well, just now I have read. The head of the institution, or in absence of the head of the institution, any other member so and so shall submit to the board 3 copies of the report on the co-option of the member of the committee on the committee as per specimen form 5 MC through the District Inspector of Schools or the Director of School Education West Bengal with an advance copy of the board within 7 days. So every time for formation of the managing committee, the permission of the board is required, and the board has to be intimated regarding the formation of the managing committee. This is my first submission. Second is, if the board does not grant permission to the managing committee is defunct. So Rule 28(8) and Rule 31 and 32, Rule 32 and 33 of the Management Rules of 1969 is very much important, where the rule has specifically empowered the board to give an approval to the managing committee. Where is the formation? But I request your lordship to see whether this managing committee is a valid managing committee or not, because I have annexed one document to the writ petition once. Your lordship, kindly have a look through the writ petition. For 13 long years, this managing committee is continuing. And the board has issued an order, page 58. Kindly have a look to the order of the board in the writ petition. In 2018, page 59.
Of the writ petition?
Of the writ petition.
Yes.
Page 58 is the finding. The school authority has challenged. Got it? Yes. The school authority has challenged the order of the board communicated memo number so and so on the ground that hearing dated so and so held by the ad hoc committee lacked quorum, but due to inadvertent fact was not mentioned in the said order issued by the board, that the ad hoc committee, by virtue of an unanimous resolution adopted in its minimal, I am not reading it. Then the said managing committee got extension from time to time up to 31st of October 2017. In the meantime, the school authority has asked time and again to reconstitute the managing committee, but the said authority, flouting all democratic norms, have been evading managing committee election on one pretext or the other. So the so-called managing committee has no locus standi to take administrative decision of the school, as its prayer for extension of the managing committee was rejected by the board beyond 31st of October 2017. The school authority, citing WPS so and so, is still which is still pending before the Honorable Court, prayed for extension of 10 years. Then hence, to break the administrative impasse, the I President so empowered so and so, adopted meeting minutes so and so, agenda number so and so. See, Ashish De SI Circle so and so of this DI of Schools Kolkata is appointed as the administrator. But this order was challenged by the school authority before this court, and the petition is pending. Now, Mr. Jana can apprise your lordship what is the status of the managing committee. The same managing committee has dismissed me. This is number one. Number two, whether the managing committee, without following Rule 28(8), without taking the permission from the board, can take a decision to dismiss any approved or unapproved teacher. Just as Shokota Bhattacharya has said no. It was assailed. the division bench did not interfere. Now the third point is regarding the private affair of the board, managing committee. I have just now prayed before your shown before your lordship, rule 32 and 33, where the election of the managing committee has to be notified before the board through the DI or the Commissioner of School Education. So the involvement of the government is absolutely there. This is my submission. May I hand over the
Keep it with you, I'll see. Yes. School, the DI, board is also there. Board is a party. Yes.
Huh?
It's a 21 writ petition.
This is, I know him, my lord. In PR Chatterjee also governor, sir.
PhD, I was not the petitioner.
board party আছে
Yes, the board is the party.
Yes, board is a party.
বলো না
Board is very much a party.
But copy not solved, my lord. But my lord,
I don't
heard,
know,
my
it's
lord,
a
what
petition
I
of
heard and what I got from regarding the
21.
status of the managing committee, my lord, that the school can apprise, I don't know. But my lord, this what I heard hearing over here, my lord, the school has termination terminated the petition in 2020. Now, my lord, my learned friend is showing that the 2028 rules have not been complied with by the school, my lord. Here I say, your lordship, after 2018, my lord, there
Why
is a-
don't you take a copy? You give a copy.
Yes.
rule 28 has been repealed.
No, not repeal, omitted.
Omitted, not
Omitted.
repeat.
We can go through it and come back.
Lordship.
Right.
Fair enough.
Without making piecemeal argument, go through it and come back. Please come.
এইটাই আমি দিয়ে দিলি না অন্য কপি দিবি
না আমি কপি তোমার দিচ্ছি আমার কপি
তাহলে একটা আজকে দিয়ে দে দেখে নিও আজকে
Learned advocate representing the board submits that copy of the writ petition has not been served. Stop. Let copy of the writ petition be served upon the learned advocate representing the board for obtaining necessary instruction. There is no requirement of filing opposition. This is a point of law.
point of law
2 weeks.
lordship
Lordship.
Today is 3rd, 17th of February. List on 17th of February.
কত নম্বর আইডি
February.
আচ্ছা,
take back the orders of this is
এফিডেভিট এটা ফেরত দিয়ে দিন। এফিডেভিট
এই
কপি
কত রে? এটা কি WPA নাম
একটু দেখুন তো এটা অরিজিনাল
দেখো, original map টা আছে।
হ্যাঁ এটা আমার কাছে আছে
12,447
যেটা বলছে সেটা নয়
হারিয়ে ফেলতে পারে।
ম্যাপটা আছে।
এখানে তো অ্যাডভান্স করা রয়েছে,
বাইশ
serial
না?
number
কোন সালে?
লিখে আছে।
দেখো
12,447
ওটা কি যাবে? যেতে পারে? আমি কপিটা রেখে দিচ্ছি। Affidavit in opposition কিছু আছে কি? Legal কোনো
I hand over the opposition. হয়ে গেল।
কল ফট করুন। Affidavit in opposition. Affirmed on 31st of August 2022.
আর opposition কোথায় রে?
Today by the learned advocate representing the school. Be retained with the records. Stop. The original affidavit in opposition is not readily available. Stop. The department is directed to trace out the original and place the same in the file. ঠিক আছে, learned advocate representing the board shall come ready. আমরা তো আগেই বলে দিয়েছি ইনস্ট্রাকশন নিয়ে আসবে। Yes.
Grateful lords.
Item
What
number 5
opposition দিয়ে?
filed opposition today.
Yes, my lord.
Original.
Original.
এটাতে original opposition হবে। 5 and 7 original opposition file হয়েছে by the school. Mr. Boisho, you also
Lordship.
instruction whether you can appear in 5 and 7.
But Lordship, if the directed, then I will appear, Lordship. Otherwise,
Check up if anybody has been
Opposition
engaged
দিয়েছে,
or not.
দাদা।
আচ্ছা তাহলে
Yes.
একটা লিখে নিন তো, let notice be served
আগে
in item numbers 5 and 7. Let notice be served upon the learned advocate representing the state respondents, intimating the next date of hearing.
এই 3টে অপোজিশন দিয়েছে।
Grateful. Great.
Lordship, grateful.
This matter, in fact, I mentioned initially,
Lucas, one petition dismissed, 2 allowed.
It was mentioned by somebody and it appeared in the list last week for correction of the order.
In well plus submersible pump.
Right.
It's a well.
But then there it was mentioned by the learned advocate.
Their petition already dismissed by your lordships. Kindly see.
Which is your writ petition?
both writ petition was taken up together by common order.
Which one?
One
4261.
426 with Uday Hati, 26211.
Acha. Now tell me, in Uday Hati, where have you mentioned that it is well or it is submersible pump?
For your lordship, going to on all this matter, this is a order of June
Page
2025.
Page 23.
Page 23 of the writ petition.
Writ petition, in 26.
Yes.
To 1 page 23, kindly see the sinking new well submersible in G, column clause 3G, type of pump to be used submersible. 23, kindly see. Page 23. Page 23, clause 3, G, type of pump to be used submersible.
But then at the top, permit for sinking of new well.
New well, but there's a submersible, that is the geologist and government submitted report also. The geologist,
but then
pump.
Your if the form says sinking of new well, why you want submersible to be?
But that new well, that is similar type of meaning, as such.
I do not know. This is what the government form is.
The form is but this is 3.5 submersible. G this is the submersible.
Yes. Where is the problem?
But that problem is when you new well, their meaning, is the police meaning is the only Kua. That there is no permission is necessary digging Kua. New well means their meaning police authority.
What they are thinking out of the order is not for the court to see, right? You have made application mentioning well.
No, submersible and also the municipality also giving permission and your lordship directed the state authority to submit a report. But kindly see the report also submersible pump.
Very well. If they show it to the police, why there is a requirement of making changes? Nothing. Next. order over.
Three I appear for the petitioners.
Yes.
Secondary board.
I am for the state.
I have taken Then your lordships were in connection of the correction. I file an application. Well, that application may be disposed. Otherwise, my lord, that
But then this was mentioned and for correction.
because my lord, the order was passed in long 3 or 4 months before. As such, we file an application being can number my lord 2. That application be disposed.
তাহলে can 2 তে একটা অর্ডার করে নিন তো আইটেম 2 এর can 2 the instant application has been filed in connection with a disposed of writ petition. Stop. I have heard the submission made on behalf of the petitioner / applicant and is of the opinion that there is no requirement of making any correction or modification in the order disposing of the writ petition. The connected application stands disposed of. Yes.
Well, at item 3, I appeal for the petitioner. Well, I'm the headmaster of a school. Well, your lordship kindly have a look to page 41.
West Bengal Central School Service Commission, is anybody there?
But they
But they
not
have
required.
all looked.
All right. There is
Page
one.
41.
1 minute. Respondent number 8 is a private respondent.
School. Respondent number 8 is the just a second. Is the school of mine. Wherefrom I have been released yesterday. Now the 10 is the school recommended school. Well, both of them have been served. Copy has been served. The affidavit service is there before your lordship. Now the difficulty is, if your lordship can turn to page 41.
41.
Yes, of the writ petition. But 10C has been invoked, and I have been transferred from my present school to the recommended school at Howrah. Now, after this, page 42, the recommendation was issued by the commission on 8th of January, and the board on 28th of January has issued the order of transfer, transferring me to the recommended school. Got it? Page 43. Now, let kindly have a look to this document.
What is this?
I have mentioned it. This is the mail that has been given to me by the recommended school that you have to bring no litigation certificate from your present school. Now, yesterday, I got the release order. The first page is the release order from my present school. I have been handed over all the documents, and they have issued the release order. Now, the only difficulty is that without the no litigation certificate, I cannot go and join there. The date which has been mentioned by the board, if my lord kindly turns to the letter of the board, page 43. 28th, the board has issued, and I have received it on 28th. After this chart, it has been ordered. My lord got it? It is herein ordered that the concerned school which release the incumbent within 5 working days from the issuance of this order. Done. And the incumbent shall join his or her assigned post within 3 working days from the date of release. But how can I join? Because of the pendency of a criminal case. Kindly turns to page, next page, page 44. The next date is 11th of February. Now, in
This criminal case is regarding what?
Service
related matter.
But the criminal case has been registered in 2020. Since 2020, kindly have a look to this bunch. Just now I have handed over to your lordship. I have obtained the certified copy from the court below. Since 2021 till 2026, not a single witness has ever appeared before the court for deposition of witness. Every day court has granted time. Every day the court has granted time. And the next date is 11th of February. I hope on that day itself, nobody will turn up. What is my remedy?
Yes.
No, may I, your lordship?
Yes, please.
First of all, your lordship, he has not annexed the thing which he is challenging or he is saying that has not been annexed. In page 46,
I have mentioned
the communication from the school where he is transferred, that is annexed is page 46, where there is no whisper of no litigation certificate, only other documents. Now, my lord, now he is handing over a copy of this no litigation certificate which has not been annexed. Number two, your lordship, I have taken instruction. Well, at the school where he is to get transferred, my lord, the school has got no authority under any law to ask for a no litigation certificate. So, my lord, if the school has asked, it has asked wrongly. So, my lordship can direct the school to allow him to join without this no litigation certificate, subjected the other which documents regarding his career.
I have. Also.
So, my lord, there is no rule.
But in paragraph 7, I have specifically mentioned it. Page 8.
So, the pendency of a criminal proceeding, your lordship, does not, it is a transfer under 10C. It is an administrative transfer. Well, a no litigation certificate,
No way connected.
no way connected.
Great.
It can only be asked if the petitioner himself asks for a transfer. It is an administrative transfer.
Paragraph 7, I have mentioned about this document. Page 8.
And well, nobody knows when this criminal proceeding will be concluded, my lord. For that, the transfer cannot be given a go back.
Paragraph 6,
It's for the state. Yes. Please come.
Paragraph 6, I have mentioned.
The petitioner was serving in page 41 present school লেখা আছে Kashwara. Stop. He na she. He. Acha, he has been transferred to Howrah Robindra Deshbandhu Vidyalaya, Howrah. এটা 41 পেয়ে যাবেন. By the School Education Department under section 10C of the West Bengal School Service Commission bracket open amendment bracket close Act, 2017. The recommendation for transfer in the post of the headmaster in terms of section 10C of the Act was issued in favor of the petitioner by the Commission on 8th January 2026.
Present. Respondent number 10 and 11.
উপরের ডেটটা হচ্ছে 6/1/2026 ট্রান্সফার হলো এনসিতে on 6th January 2026.
Teacher in charge.
Of which school?
The transfer
Recommended school.
Recommended school.
10 and 11.
All right. Howrah Robindra Deshbandhu Vidyalaya.
Hi, madam. Party in person.
Party in person. Yes. Record his appearance. ভদ্রলোকের appearance. কি নাম আপনার?
Raja Das.
Teacher in charge. Appears in person. এই চিঠিটা কি আপনি ইস্যু করেছেন নো লিটিগেশন সার্টিফিকেট নিয়ে আসার জন্য? কোন আইনের প্রভিশনে আপনি এটা ইস্যু করেছেন?
ম্যাডাম, আমাদের কতগুলো প্রচলিত রীতি আছে যেখানে হচ্ছে আমরা
প্রচলিত রীতি
মানে আমরা যেখানে হচ্ছে এই ডকুমেন্টগুলো
on 28th of January 2026. The said order mentions that the school will release the incumbent within 5 working days from the issuance of the order of transfer, and the incumbent shall join his assigned post within 3 working days from the date of release.
Respondent number কত লিখে দিন?
Stop. The petitioner has been released from service.
হ্যাঁ, সই করতে লাগে।
Your date of release?
That my date of release yesterday. The document, first page, 2nd of January.
Second February. These
The
loose
first page,
documents.
first page. First page.
2nd February. 2nd February 2026. But the petitioner alleges that he is not in a position to join the recommended school as the teacher in charge of the said school directed the petitioner to submit a no litigation certificate issued by the concerned and competent authority along with other documents for the purpose of joining the school. Stop. Next. Learned advocate for the petitioner submits that the petitioner is in possession of all documents required for joining, but for the litigation certificate. Stop. It has been submitted that a criminal case against the petitioner is pending consideration before the court of the learned judicial magistrate, third court, Hooghly, in GR 649/2020. Stop. Because of the pendency of the criminal case, it will not be possible for the petitioner to produce the no litigation certificate. Stop paragraph. It has been submitted that there is no provision in law requiring submission of a no litigation certificate to join the recommended school in accordance with the transfer order issued under section 10C. Stop. Prayer has been made to direct the recommended school to permit the petitioner to join on the basis of the other documents that shall be produced by him. Paragraph. Learned advocate representing the board submits that the recommended school does not have any authority to call for a no litigation certificate. Stop. As the transfer order was issued under section 10C, there is no legal requirement of production of a no litigation certificate by the recommended school. Stop paragraph. The teacher in charge of the recommended school is appearing in person. Stop. It has been submitted that the school does not have any intention to restrain the petitioner from joining. Stop paragraph. Upon hearing the submission made on behalf of all the parties, it appears that the teacher in charge's communication, that the communication of the teacher in charge requiring production of a no litigation certificate is not supported by any provision of law. Stop. As the order of transfer is an administrative one, there is no requirement of submission of a no litigation certificate. Stop. As admittedly a criminal case is pending against the petitioner, the petitioner will not be in a position to submit the no litigation certificate. Stop. The same will in effect frustrate the order passed under section 10C. Stop. Next. The instant writ petition accordingly stands disposed of, directing the recommended school to permit the petitioner to join, relying on the documents sought for, barring the submission of the no litigation certificate. Step. The petitioner is permitted to join the recommended school on the basis of on production of the documents
Page 46.
appearing at page 46 of the writ petition. Stop. Writ petition stands disposed of.
I'm grateful.
Thank you.
May I get a very urgent server copy?
What happened? Lift installed.
Out of 14, 13 installed and member are happily, all the members are happily enjoying it. Only 14, 90% has been completed.
Last time I see recording, out of 14, 11 were installed. Now it goes up to 13. When will the 14th be installed?
13 completed and members are happily enjoying.
Right.
Only 14 number, 90% completed, madam.
Oh, 14, 90% completed. What is to be done?
Your lordship disposes of happy ending to a
No, all 13 members.
happy ending to
Still
a
want it to remain pending.
My lord,
কি
my
হবে?
lord,
He has gone much more because of the intervention by lordship and keeping the matter pending for long.
no,
No,
no. I have
one
no
way it
intention,
has
ma'am.
been done. Otherwise, it wouldn't have been. Because one was seeking
What to do? Dispose
implementation.
it off.
My lord, according to my instruction,
Yes.
they are fearing that the person who is active challenging this decision of my lord, he is in the 14 number building residing. That's why, as per instruction, my lord.
আচ্ছা ঠিক আছে লিখুন তো সেম অর্ডারটা হবে এখানে আউট অফ 14 লিফটস 13 হ্যাভ এখানে 14টা থাকবে 11 এর জায়গায় 13 হবে 13 আর অলরেডি ফাংশনিং যেটা আছে সেটাই 11 এর জায়গায় 13 হবে it has been submitted that the 14th lift is uh, um, is in the process of installation. Stop. Part work has been complete, but balance work is still remaining. Stop. এবারে 2 নম্বর থাকছে 3 নম্বরে ডেটটাকে চেঞ্জ করুন how long will it take to complete
My lord, end of April or May, my lord, first week of May.
why
My lord, April, my lord.
how long does it usually take to, because you say 90% of the work is over
My lord, sometimes
Then-
electrician, sometimes very hazardous process for installation of lift, my lord.
after পয়লা বৈশাখ all right
After summer vacation.
Like with this.
the earlier it is disposed the better why keep it pending we are in
Just to give a fixed date,
no
more or less, 5 days plus minus.
see today is only 3rd of February
Your lordship
got
keeps on
March.
the last week of March.
He's got the whole of February, whole of March, and after Poila Boishak, say 30th, last day of April, 30th of April.
My lord,
But more or less 3 months' time.
my lord,
Finish it up.
my lord.
30th of April.
Deeply obliged, grateful.
Well, I am for the petitioner in this matter. There was an order passed by this honorable court which has been complied for filing a report by filing a report.
State.
DI has filed a report. Malar, one interesting portion is page 45. It was referred to DI for transfer.
This is a transfer matter.
Yes, my lord.
Where is the rejection? Let me see.
Not been rejected formally. School
Alright,
has
let
not
me see.
sent it. Page 45, my lord, will kindly see.
Single teacher. Thank you.
Single teacher issue.
Single
Yes.
teacher issue has not been considered because the school said we have no objection. NOC has been given by the school at page 41. Page 45, School Service Commission has recommended. But to the
45 recommendation in 2019. We are in 26.
thereafter, the vacancy particulars were supplied to the School Service Commission.
Yes.
The School Service Commission, by the DI is saying we have supplied this vacancy position. Nothing happened. Thereafter, Utshosri came. Even pre-Utshosri quota, my lord, has been filled up, page 46. Pre-Utshosri cases, my lord, all have been given appointment. My case, my lord, also was recommended. DI has supplied. No transfer was made.
Why do you seek transfer?
It is I am a very sick person, my lord, lady, my lord. The distance is, my lord, 77 kilometer, my lord, every
You
day.
make fresh application. I'll give you leave.
My lord, one prayer I am making your lordship is this, my lord. Since they have in their affidavit had said, my lord, kindly check the report, my lord, given by the school, by the DI. Kindly take the report given by the DI.
Where is the report?
Report ta koi?
It is not here on record.
Page 43 is the, my lord, extract. Page 43 was appointed by court, my lord. See, no one appeared.
My lord.
Yes, his report.
In
the report.
Right.
No, my lord, actually, GP office, our name is not recorded. That's why.
Despite court's direction, he has not been.
He has filed the affidavit.
It is not on record, sir.
It is supplied by Arindam Chatterjee.
I understand.
Page 43 is the extract, my lord. Page 43. Utshosri extract.
Oh, 21 is the extract. She is a single teacher, head of the institution to the applicant.
A single teacher issue.
Doesn't matter. This court has considered it single
Yes,
teacher
yes.
issue.
Same order.
Single teacher. Fresh application to be made. Head of the institution will consider.
The point is, before your lordship, they are saying that teacher is not available in the area. We are
Doesn't matter.
searching it
The
out.
court has considered it and passed order.
Great. That's good. Grateful.
And for the petitioner, my lord.
Yes.
For the commission. My lord, kindly come to page 22, my lord. Only one thing. Kindly take, this is the status. It does not annex to the writ petition because
Transfer application.
yes, single subject teacher matter. My lord, kindly see.
Give it to him.
Just handing it. Soft copy to the soft copy to the. It was incumbent upon the DI to follow 3rd January, but the burden has been shifted to the school.
2022.
Yes, it has been shifted to the school. Kindly see.
Single teacher, same kore deben.
My lord, I'm giving the order of your lordship. This is the observation.
Single teacher, make fresh application.
Fresh.
The head of the institution will consider.
My lord, that observation irrespective of.
All will be there.
That is.
All will be
that
there.
is the order of your lordship.
Yes.
Your lordship is
Take it
directed
back,
me to
don't-
make fresh application.
Yes.
Very well. Very well. Good.
My lord, I am appearing on behalf of the state.
My lord, kindly come to the.
This is also transfer?
Yes, my lord.
Yes, please.
Kindly come to page 46. May I just see the
9 January 2023.
I don't know what
the point was challenged.
I'm showing. My lord, kindly. Yes, I'm showing that. My lord.
The presses the fourth application I have no.
No, I'm telling you lot. I have a reason before.
Was submitted by the
Last occasion it was not been
taken
placed before the honorable court, possibly.
petitioner. That application shall will come rejected and returned on the same ground.
Kindly see, my lord.
Wait 1 minute. The petitioner then submitted 4th application 22, which was returned on the lack of documents. Challenge the rejection. The DI failed to take a step. Listen, I see your last rejection was third one rather was in November 21. You submitted 4th in February 22. I will still say you file a fresh application, which will be considered.
Yes, only one thing, and yes, my lord, if your lordship has said that, my lord, no
Yes.
problem. Only one thing, page 46, I just clarify. Kindly see page 46 top.
Are you still a single teacher in the school?
I'm still a single teacher in the school.
All right. Single teacher?
And that order may be.
Yes.
Possible.
Fresh application and head of the institution will consider.
In accordance with this 3rd January, because my lord, school has no role to play here. School is just to forward to the DI.
Yes.
Kindly mention that in accordance with 3rd
Disclose.
January notification.
Yes.
In one order, that observation was not there. That is why I just handed over a copy. That irrespective of the fact.
Yes, it will be there.
Grateful to Lord.
But here, this matter, my lord, pertains to, my lord, the SLST2 selection process, where, my lord, the petitioner before your lordship has
SLST2 selection process is SLST represented. Commission.
Yeah, my lord, I am appealing.
Yes.
I am appealing, my lord.
All right, all right.
So, my lord, what happens here, my lord, my lord, have been, my lord, competing for this examination for the history post, assistant teacher for the history. So, my lord, there have been, my lord, some questions which are, some of them, my lord, which were said to be out of syllabus, and some of them were not, the answers were not right and everything. So, my lord, here in a particular question, my lord, I said that this is out of the syllabus. And, my lord, for which, my lord, for substantiating my claim on the earlier occasion this matter came up, my lord, I in the writ petition, my lord, annexed, my lord, the syllabus of the SLST 2025, and also, my lord, the relevant books and the contents of thereof, under which chapter, my lord, this particular question falls. Be that as it may, my lord, thereafter, my lord, the question, my lord, came, my learned senior, my lord, took the question that right now whether this point could be agitated after the publication of the final select list.
But only one thing that he has not given the objection at the preliminary stage.
So thereafter, my lord, what I said, my lord, I submitted objection at the preliminary stage. First of all, I did. My lord, I specifically, my lord, gave mail.
All right.
And be that as it may, after that, my lord, by publication of the final list, final answers, my lord, my contention, I said that even in spite of that, the commission, my lord, has corrected the questions of someone else's as well. To substantiate that claim, lordship has given me the liberty so that I could, my lord, file a supplementary affidavit to that effect. Kindly seize, my lord, the supplementary affidavit which I have filed already to your lordships. My lord, only one page, because it is an admitted position that the last list was published, the final was published in 9th of November. My lord, kindly, or 7th of November, subject to correction of my learned senior. My lord, kindly seize page number 14 once, 1/4.
Yes.
My lord, this is the notice, my lord, that has been given by my learned senior's client, which says that this is to notify all concerned that there were few clerical errors in Bengali geography answer keys published in such and such. These are now being corrected and results of these two subjects are being republished. The correct answers as suggested by the review experts are as follows. This and this. So, my lord, state that since these corrections could be made at the date of 10th of November, my lord, my case, but I did not say that before this honorable court right now that I should be given with the mark or something. But I just say that at least an expert committee, my lord, should comment upon this. My query or my lord, contention before the writ petition.
Show me that you objected at the very first stage, the preliminary stage.
My lord, if I could take your lordship to my mails that I have given directly, my lord, that your lordship will find at page number 53, which would be, my lord, the last page of my writ petition.
All right. This is 11th of November?
This is 11th of November, yes.
No, but then
This is 11th.
time within which the objection.
My lord, admitted position on the earlier date also, my lord, I said that I did not do that.
Then?
I did not do that. What I did, my lord, after this mail, my lord, I said that several other candidates' things, my lord, have been corrected or expert committee report have been accepted.
No, if you were genuinely aggrieved by the answer in the preliminary answer key, you should have objected then only.
My lord, I follow, my lord. So
Then?
I tried to, my lord, take the contention that
No, please.
this has been done in case of other persons.
No, please come.
So this is what only my submission.
The petitioner participated in second SLST, 2025. Stop. He is aggrieved by the manner in which his answer has been assessed by the authority. Stop. It appears that the petitioner failed to submit any objection within the prescribed time period as mentioned in the recruitment notice. Step. The petitioner submitted an email after publication of the final answer key. Step. Paragraph. The prayer of the petitioner seeking re-evaluation of the petitioner's answer script and to award marks to him, not to her, cannot be allowed. Step. Had the petitioner objected within the time limit as prescribed, comma, then the court could have come to the aid of the petitioner. Step. In the instant writ petition fails and is hereby dismissed.
Lord, say I am stayed in this matter, Lord.
Yes.
But her name is there in the final list. Panel.
Is there?
Then that's good.
So
She
general
doesn't get
category,
marks for counseling. She'll get a better position in the school. I understand.
general category 179, female category 58.
Yes. Yes. Time for the petition. WP. Yes, please. 654. Second SLST matter? What is the grievance?
My lord, the petitioner, my lord, made application, my lord. Lord, kindly come to page number, my lord, 40, my lord.
Similar order. Yes.
My lord, the post-graduation marks, my lord. My lord, it is, my lord, I'm led by Mr. Sudarshan.
Yes, page 40.
My lord, page 40, my lord, the petitioner marks, my lord, ought to be 600 instead of 594. Now, the bottom portion, my lord, got it, my lord?
590 marks obtained is 594.
It ought to be 600. Kindly turn, my lord. Page number, my lord, 44. Bottom portion, the petitioner marks.
Full marks 600.
So, my lord, it ought to be 60%. Then, my lord, the petitioner automatically get 2 marks, my lord, extra 2 marks. In that case, my lord, kindly turn page number 46, my lord. And the cut-off marks is 52. And
But then this form you filled up, isn't it?
yes, my lord, I filled up. I made.
So how could you decrease the marks and fill up the application form?
How, my lord? It is mistake. It is a mistake and on the part of the petitioner, my lord. But my lord, my case is lies about, my lord, the action of the School Service Commission Act, my lord. Kindly turn, my lord, page number 47 onwards. Thereafter, my lord, I place the rule and respective judgment in this regard, my lord. Kindly turn, my lord, page number 47.
47.
The fact is, the case is that, my lord, the petitioner marks ought to be 600 instead of 594. In that case, my lord, petitioner called for the verification. Kindly turn page number 47, my lord.
Yes.
Guideline for editing of application on second SLST 80 2025. This is for information of the applicants under second SLST 80 2025 for classes 9, 10 and 11, 12, that they will be allowed to edit their application through online in respect of field, that is name, date of birth, gender, photo with signature during the period from 30 July 2025 up to 3rd August 2025. That is after last date of online application. They only allow the edit option in respect of the name, date
Yes,
of
yes,
birth,
then?
gender. Then, my lord, very next notification, that is regarding edit option regarding caste category. Thereafter, also, my lord, edit option, page number 49, existing roll number, teacher code, unique school code, date of first joining, experience count. So, experience number is also altered. 7 accept academic qualification. My first limb of my lord, submission is that, my lord, in the rule, whole rule, there is no such option or there is no such power is given to the School Service Commission. They will give the edit option after last date of application. But they did it. But they did it selectively to their favorite candidate. If I construe it, yes, no, my lord, yes. Favoritism lies on that, my lord, on which count, my lord, they give that edit option. Experience number edit option was given. The name, gender, but why not? My lord, if I construe it independently, if a authority, Article 12 authority give the edit option as a whole, why they choose to give edit option to a particular
First, you
category?
tell me, how could you put
Yes,
in
yes,
wrong number?
Yes, my lord.
You are applying in a public selection process for classes 11 and 12.
What happened, my lord, in case of, I inquired it. Same question I inquired it. But what happened, my lord, this village boy, my lord, they usually, my lord, fill up the forms in the
Cyber cafe.
Cyber cafe. Suppose, my lord, 3 or 4 candidate, my lord, fill up the form in the same cyber cafe. Because of that, when they open that browser, suppose that earlier candidate marks was 594. So it automatically can, and the candidate.
And the candidate failed to notice this. You filed the application in June.
Sometime, usually, if they want to, kindly give me some time. Because if a person wants to get benefit, usually what he will get? Or he might increase the mark.
Yes.
In that case, he never did it. Usually, if he wants to get benefit, usually give higher marks. But in that case, in this case, what happened? Instead of 600, it became 594. Because of that, I inquired from the candidate. He says that in the same cyber cafe,
Several other candidates also went, so somehow it has gone down wrongly.
But my case is lies upon that. If they not give the edit option to any candidate, then I have no case. But after last date of online application, they gave edit option, the Article 12 authority edit option, with a particular class category. They give edit option for the name, date of birth.
Has your document been verified?
Document
verification?
Although in the rule, there are 3 times document, although they take verification 2 times. But usually they ought to verify it, but they're not verified it.
Documents were not verified.
Not verified. So, my respectful submission in this stage is that, let's verify my document, because it is.
But then, provided you reach the document verification stage, if you do not reach that
If I reach, that's why page number 46. That's the reason, my lord. I annex page number 46. If I get 2 marks, it ought to be 53 automatically, my lord. Otherwise, my lord, what is the use of that writ petition?
Cut-off mark is 52 and
I got 51. So, my lord, if 2 marks added, so, my lord, I come with the zone of consideration. That's my case, my lord. And, my lord, in this regard, my lord, there is
late stage.
My lord, no, that is not a belated stage, my lord. In this regard, my lord, one Madhya Pradesh High Court judgment is there, my lord, by quoting the Delhi High Court judgment, my lord, minor error, my lord, is not get any benefit from that this minor error, my lord.
Let me hear the commission.
They gave the edit option to others, my lord. In others category, my lord. It will
Let me hear the commission.
There is only one candidate.
1 minute. Let me hear.
First of all, that kindly your lordship has already marked it that he has given the quoted wrong number. That's his fault.
It is a mere mercy before the commission.
I am just telling you. Not today there's no scope, because when the preliminary list was published long back, your lordship knows that November. That time her name was not appearing. He did not come. At a very belated stage, we can't. If there is anything done, it will be a topsy-turvy. Then again, we have to start the process from there. Then the verification, then the interview. It is impossible. Your lordships have dismissed one application. Just that is Urpita Pal's case. Can you hand it to me? 8 December.
Instead of
see.
percentage, she disclosed a percentile. I know. Any appeal against this? No.
No.
Not that. I wish somebody could have appealed. Because I don't know what to do. If the commission starts revisiting all the documents, then there may be several such candidates who are going to come over here. This is the reason the court doesn't want to interfere in these matters. You go through this judgment. This is against you.
Yes, my lord, judgment, but that judgment, I believe, my lord, although I get it here and now, I believe, my lord, although that is not binding precedent, but it's
No, it's
have
binding,
persuasive, my lord.
Thing is, you say this is a mistake and it is admitted that it is a mistake.
Obviously.
Why did you come so late? Had you come earlier, see, this was dismissed
On 8 December.
December. We are in February, 2
I
months.
came, my lord, on that day, my lord. I came with the petition, my lord, filed on 8 December itself.
And see, it is coming up so late. Even had it been on that day also, the fate would have been dismissal. But then...
my lord, I just go with this judgment, my lord.
Go through it, come back. I'm not in your favor.
But the point is that, my lord, they give the edit option. Then, my lord, I have another submission is that, my lord, regarding the empowerment.
You have a bona fide case?
Yes,
then only I'll go into. I do not see
46, my lord,
a bona fide on your part.
my lord, if I want to get benefit by giving the...
It is not only a matter of getting benefit. It is a matter of disclosing proper information. You can be held up or rather hauled up for not disclosing proper information.
My lord, with deepest of respect, my lord, then, my lord, School Service Commission ought to cancel each and every one online application who filled the wrong application, my lord, in respect of name, in respect of...
That is the reason for the benefit of the students.
Equal opportunity in public employment, that's my fundamental right. Yeah, after last date of online application, if they altered others person details, my lord, from where they got that power? Rule says so. After last date of online application, they can't do nothing. But School Service Commission gave the opportunity in the favorite candidate. Obviously, my lord, the the rule never empowered the School Service Commission because rule framed by the state government. Rule never, my lord, never give, my lord.
YouTube
Lordship's leave, Milord, may I go? Milord, with your Lordship's leave, Milord, can I leave, Milord?
Yes, you can leave.
Leave, Lordship.
The petitioner participated in second SLST for level class 11 and 12. Stuff. He incorporated incorrect marks obtained by him in his postgraduate examination. Come back.
After vacation.
Stop. According to the petitioner, the incorporation of marks was an inadvertent error. Have you mentioned the cyber cafe and all these things over here? Then you didn't make out a case also. Acha. কি বললাম? Inadvertent error. And the petitioner will not gain anything out of the wrong incorporation of marks. On the other hand, he is losing 2 marks for account of such wrong recording. Stop. Paragraph, it has been submitted that on 3 occasions, the commission permitted the candidates to edit their details in the application form, but in none of the occasions was the option available for correcting error in the marks submitted by the candidate. Paragraph, it has been submitted that the that as the commission permitted editing of various details in the application form, comma, opportunity ought to have been granted to the candidates to rectify any error in any portion of the application form. Stop. Only, not only permitting editing of only selected fields is is in violation of Articles 14 and 16 of the Constitution. Stop. In support of the submission that minor errors can be rectified, can be permitted to be rectified, reliance has been placed on the order passed by the Honorable High Court of Madhya Pradesh, bench at Indore, in এটা টুকে নেবেন তো 15th March 2022. Stop. Learned advocate representing the commission opposes the prayer of the petitioner. Stop. The commission relies on the order passed by this bench on 8th December 2025 in WPA. Stop. Learned advocate for the petitioner seeks time to revert with further instruction. On such submission, how long? 2 weeks?
No,
Next week, 10th. Today is 3rd, next Tuesday, 10th. Yes. Yes, service taken on record. Yes.
This is not with 200 rupees application. Yes, already is not accepted, as well as the division bench passed the order in Shobnath Brahmanic.
And that has been modified in appeal. Did the petitioner? A window was opened, directed to be opened.
Yes.
Did you? Yes.
We clarify that this measure is limited to person who approach this court on this issue till 2:30 p.m. by way of filing of writ petition or appeal or otherwise. The next sentence is very important. Authorities are at liberty to deal with such the candidates who are not governed by this order in accordance. The Supreme Court says what is in accordance with the sentence. But for what the authority? 2024 SCC online SC3 4 para 14.
Yes, para 14.
14 and 13. And I came out.
Yes.
Yeah,
Yes.
It is a well-settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his or her favor, others similarly situated ought to be extended the benefit without the need for them to go to court. Thereafter, next paragraph, para 15. Here is separate, that is quoted. By quoting, will settle principle. What the School Service Commission did, put a cut of date, whosoever approach the court within a certain period of time, they only get benefit. An article will already have. So already the matter is settled, same benefit, others
But how long will this benefit be given?
It ought to given to all.
How long?
Because of that, why? Because this is a mistake on the part of the agricultural authority. They mentioned two also. One is old, sorry, part of the three. So for that reason, my lord, the candidates were confused. The confusion created on the part of the agricultural authority. Now they made mistake, and the candidate, my lord, they are suffering. Because the division bench judgment is not that you put a cut of that. No. The division bench judgment says your decision in accordance to. But they took decision that whosoever comes to the court within a stipulated time, he will get benefit.
I see this. It appears that he filed the petition on 8. 8. That is the records are same. Now, my lord, this window was open up to a particular time. He had filed the petition, but he did not avail the window. It is impossible. Well, where is he speeding there? Well, it is impossible. Everyone avails the window, my lord.
But then how will everyone get to know that there is a window open?
We have given a notice.
Notice was given.
Notice was given, my lord. Justice Boshak asked us to give a notice. This is 16th of December. Please see the notice, 16th December notice. He had put it up.
Such portal will remain open up to 6 p.m. on December 17, 2025. And up to 2:30 p.m. today, whoever filed the writ petition, portal was open. The writ petition was filed before.
Yes. So, my lord, this order was applicable for him.
He would have been covered by this order.
Yes. The authorities will open the portal at 6 p.m. today and keep the same open till 6 p.m. on, you know, my instruction is it was open beyond.
The onus is on the candidate.
11 and 12. This is also 11 and 12 or what?
11.
This is 11, 12 candidate.
Allow everyone.
Or 9, 10.
Just give me.
This is a 9, 10 candidate. This is in respect of only 11 and 12.
No, the portal was.
Some are for 9, 10, some are for 11, 12. And for 9, 10, everybody was allowed. Next paragraph is there.
But the division bench's order.
Division bench's order is not restricted to, well, with respect. You know, before the honorable division bench, if your lordship once again falls back to the order, may not start from page 1. You know, your lordship will be pleased to see, my lord, that the writ petition, the appeal.
Please come to the penultimate portion.
Yes.
Paragraph 21. These directions are limited to the selection process of 11 and 12. Specifically mentioned. Come to paragraph number 17. We are concerned in this appeal with regard to candidate. That is up to you, your magnanimity.
No, because of this order, because of the nature of the order.
petitioner not be given the same benefit? Or,
This is contrary to the
or
division benches.
anybody
Well, he had to avail it.
sailing on the same boat?
He had to avail it. Milord, please see, Milord, our notice of 16. We have handed over.
1 minute, 1 minute.
16th the notice start.
Yes, it's here. No, I have it. He has given.
No. 16.
Attached over here.
He was, I want.
This is to notify only.
I can see one paragraph. Similarly, following the spirit of the order, all candidates of classes 9 and 10
who have filed their applications form by paying the
are also given a final opportunity
are
to
also
read it.
given up to 8:30 p.m. on 17/12. And this was uploaded in our website. In terms of this, there was no further complaint.
You never know, matters are coming.
There are no further complaints. Your Lordship has also not come across such a complaint.
As indicated
Then
in
this
the...
window has to be kept open for eternity.
No. Who disentitled can...
When the notice was uploaded.
We come to your Lordship's court. We carry an appeal before the Honorable Division Bench. The Honorable Division Bench will request the Learned Senior Counsel representing the Commission that if something can be done. On instructions, it was done. And in terms of the concession of the Learned Senior as well as the Commission opened the window for a particular period, published a notice in its usual way.
All right, I will open one window from him. He'll get it.
Kindly do not.
He'll approach the division bench.
Kindly do not.
He'll approach the division bench. Get it done.
Gets benefit of in respect of not in respect of 910. That's my instruction.
Anamika got. Did she?
These are all statements from the bar. Kindly do not
check up.
We do not. How can I check up just now?
If you want, I can adjourn it. Check it up. And she applied at the same time.
Yes. And both
so it is impossible. It is impossible.
Check up. He may be wrong. Check up. Check up. If it is not there, I open my mind that I'll refer the matter to the, not refer, I'll grant leave to the petitioner to approach the division bench and get it done because you acted in terms of the division bench's order. You acted in terms of the division bench's order. Now, this court cannot direct modification or anything of the division bench's order. The petitioner will go and get opt-in order from there. Where is it mentioned that she got the benefit in 910? It could not be because after filing. True.
What I was respectfully submitting. Lordship may pass. Let him first use a supplementary affidavit disclosing exact position factually so that we can come back.
All right. The petitioner. Participated in the second SLST in respect of classes 9, 10 and 11, 12. Stop. She claims to be a member of the reserved category and had applied by submitting fees meant for reserved categories. Stop. Her allegation is that she has been treated as a general category candidate as she failed to update/edit her caste details in terms of the opportunities granted by the commission. Stop. Learned advocate for the petitioner relies on the judgment delivered by this bench on 27th November 2025 in WPA. Eta likhe neben to Somnath Pramanik and others. The judgment passed by the Honorable Division Bench in the appeal against the said order on 16th December 2025 in Mat 2115 of 2025 has also been placed before the court. Stop. Learned advocate for the petitioner relies on the judgment delivered by the Honorable Supreme Court in the matter of Lieutenant Colonel Suprita Chandel versus Union of India and others, reported in 2024 SCC Online SC 3664, paragraphs 14 and 15, wherein the Honorable Supreme Court reiterated the settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his/her favor, others similarly situated ought to be extended the benefit without the need for them to go to court. Stop. The judgment in the matter of Amrit Lal Berry versus Collector of Central Excise, New Delhi, reported in 1975 for SCC 714, has been relied upon. In support of such principle. Stop. The আচ্ছা অমৃতলাল বেরি বললাম তো, তার সঙ্গে K.I. Shepherd 714 and K.I. Shepherd versus Union of India, reported in 1987 for SCC 431, have been relied upon. দুটোই এখানে আছে, please check. ঠিক আছে? Stuff. Learned advocate representing the petitioner submits that the petitioner tried to update her reservation details within the time limit fixed by the Honorable Division Bench.
Division may not file stipulated any time. Division may stipulated a time for those candidates who approach that.
No, such portal will remain open up to 6 p.m. on December 17. This time is also there. Acha. কি বললাম? Her division bench and in accordance with the public notice published by the Commission on 16th December 2025. But even though the portal permitted the petitioner to update her category details in respect of classes 11 and 12, but her category details in respect of classes 9 and 10 were not permitted to be updated. It appears that the aforesaid fact is not mentioned in the writ petition. Stuck. Leave is granted to the petitioner to file supplementary affidavit disclosing such fact. Such supplementary affidavit may be prepared and circulated by how soon? This Friday? Or you want the weekend? See, 10th of November. Release the matter on 10th of February. Release the matter on 17th February. Learned advocate representing the Commission shall take necessary instruction in the meantime.
Because of that, why this fact is not narrated in the repetition, because this notice given on 16.
Yes, yes, I have followed it.
My lord, I appear on your statement.
Please enter your appearance.
My lord, I am.
we will.
কোনটা পাননি খুঁজে
We have to take instruction on her application.
আন্দাজে করে দিয়েছি মানে এটা ফেরত দিয়ে দিন ওনাকে
Lordship, we have to take instruction on her application status.
তাহলে আপনি আন্দাজে কি করে করলেন something.
Look, we have to take instruction on her application status.
Yes, yes, yes. Whether the petitioner says that the her 11-12 has been updated, but 9-10 has not been updated.
9-10, everybody was permitted to update 9-10 for 24 hours.
Well, just check up. Check up. It won't take much time for you to get it. Yes, next. Yes.
On behalf of the Central School Service Commission, for fresh recruitment for the assistant teachers for the class 9 to 10, 11 to 12. There is the history of this.
No, I do not want to know the history now. You tell me what is your prayer.
My prayer is very simple. I have challenged the notification.
The notification is of May. You challenge it in December. In the meantime, the selection process commenced and results were also declared. How will your writ petition and why will your writ petition be entertained?
My lord, this is the predicament I am facing, my lord. I have been.
You have to make submission.
My lord, the first and foremost, my lord, kindly comes to the order of the Honorable Supreme Court, my lord.
Yes.
It is on 3rd of April 2025.
Yes.
And the judgment was passed in 17th of April 2025. My lord,
yes.
Comes to the operating part.
Page?
My lord, page 125, your lordship.
125.
Pardon me, lordship, it won't be 125, it will be
112.
12. Thank you. My lord, the paragraph number 45, your lordship.
Yes.
The last question relates to the relief, whether it requires any modification. We find no valid ground to reason to interfere with the direction of the Honorable Court that the services of tainted candidate were appointed must be terminated and we should not require any refund and any salaries. My lord, they said the relevancy in this when for the candidates not specifically found to be tainted.
Are you a tainted candidate?
No, my lord.
All right, then what do you want?
My lord, thereafter, pursuant to this order, this notification has been published.
Yes.
The only predicament being this, I have been approaching this Honorable Court after quite a long period. My lord, I'm granting a relief to give me a chance to make a representation before this.
For what purpose? Representation for what? Did you apply?
Yes, your lordship, I applied.
You applied in terms of the notification. You are unsuccessful.
No, my lord, it is kept in abeyance, my lord.
What do you mean to say abeyance?
My lord, this is the, my lord, kindly gives me a day's time because the learned advocate on record has briefed me just now. I have been appearing before.
All right, take time.
My lord,
When?
on 9th.
Next week?
9th.
9th?
Yes.
All right, 9th. Next one also same?
Yes, lord. Come.
9th? 9th.
File you.
Take back your affidavit of service.
It's still same.
Same.
Oh, okay, Lubana to
Yes.
না এই সার্ভিসটা ফেরত দিয়ে দেবেন
Oh, oh, lovely. না না এটা
This is that hearing, that 10 marks hearing, which was continuing.
Your Lordship, we have to make our submission. Learned Advocate General is on his way. He is coming.
Why don't you start?
So I will just give a brief background on what points we'll make our submission.
All
Then Advocate General. Please hear it. Your Lordship, oh, he's here.
Say. Even say for 2 minutes.
And to start. Yes.
I'm saying go to.
Wait, I will declare it.
I'm sorry, my lord.
No, it's all right. But these are opportunities for the juniors
Yes.
to grab.
Yes.
And
Definitely.
wait till the senior comes.
But in fact, these opportunities are getting rare. It's
The
not as-
seniors are jobless, you say?
No.
Then
I'm saying from the court's perspective, not every court is kind enough to give that opportunity.
that is different.
But that difference is.
I don't comment
No,
on this.
Lordship need not. Neither I am commenting. Lordship need not. I don't want. But I'm saying these opportunities are actually, which we have heard stories about it from our seniors. And we also say that is getting very scarce.
No, my lord, your lordship has been pleased to, my lord, hear several learned counsels in the matter. So on facts, I don't think, my lord, I need to, my lord, dilate any further. But I'll try to be as concise as possible. But my first submission would be in the form of exclusion. Exclusion in the sense, number one, my lord, no argument has been advanced before my lord that prior teaching experience is not required. Considering the nature of the job, considering the post prior teaching experience is uncalled for, no submission has been made to this effect. The corollary is prior teaching experience can be one of the qualification.
Yes.
Number two is no argument has been made that owing to the prescription of prior teaching experience, the inexperienced, if I may dissect them into two classes, the inexperience will be completely eliminated. No argument has been made. The argument is that if you provide for prior teaching experience, then the selection would be one-sided. Milord, I remember, subject to correction by your lordship, Milord, because I was always not present before my lord, Mr. Bikash Ranjan Bhattacharya submitted that except this prior teaching experience, other things are level playing field. Therefore, my second point of elimination is that no argument made that the inexperienced candidates would be completely eliminated. The argument is that it would be one-sided in favor of the experienced one. But these are the two fundamental
exclusion that I intend to make. The third, which is a somewhat in the nature of an exclusion, is that why challenge the 2025 rules? Because a line of argument at the beginning was there that Supreme Court meant that 2016 or the fresh selection should be as per the 2016 rules. To that, my lord, this is again made in the form of an exclusion also, that take, or assuming for argument's sake on hypothetical basis, if I assume that the 2025 rules is declared to be invalid by this court, but we cannot go back to 2016 rules because there was a 2019 rules in between. Or in other words, the principle which has been laid down by your lordships are that if a rule is declared invalid, that would not revive the superseded rule. Because the superseded rule or the repeal or the rule which has been repealed or the law which has been repealed, on its repeal, it has gone out of the statute book, it has gone out of the rule book as if it never existed. So, my lord, blood cannot be infused to a rule which has ceased to exist by dint of a legislative action. Therefore, we cannot go back to the 2016 rules.
Yes.
Therefore, my lord, what we are left with fundamentally are on two aspects. Number one is, my lord, whether, my lord, weightage can be granted in a selection process. Weightage can be in various forms. Weightage can be, say, age form, weightage can be in marks form, weightage can be in experience form. So fundamentally, the first question which I need to address, your lordship, is whether weightage can be given, my lord, in a selection process, number one. And number two is whether, my lord, the selector can choose between the experienced and the inexperienced. But these are, my lord, the two fundamental arguments which, my lord, I will be advancing before my lord, in support of the rule which has been framed, my lord, in exercise of powers, my lord, under the or the subordinate legislation which has been framed. Now, my lord, first, my lord, I would like to, my lord, confine the mode of challenge to subordinate legislations. Where your lordships have held that the subordinate legislations do not enjoy the same immunity as that of the parent legislation, or in the sense that the presumption of validity at the very beginning, as is applicable in case of a challenge to a parent statute, is not applicable in its full vigor when a subordinate legislation is challenged in court. Therefore, my lord, the Supreme Court has culled out 4 or 5 grounds on which the subordinate legislation can be challenged. Those are, first is legislative incompetence, where no one, in my very respectful submission, has said that there is a legislative incompetence. The second is fundamental right violation, which I'll address, Your Lordship. The third is infraction of any other provisions of the Constitution or other constitutional rights. Second and third may require, my lord, Your Lordship's attention. The fourth is not conforming to the authority granted by the primary legislation. Not conforming to the authority granted by the primary legislation. I don't think, my lord, Your Lordship has been addressed on that also. The fifth is repugnant to the parent statute. I don't think that has also been addressed, Your Lordship. The sixth is, which is somewhat ticklish, is arbitrariness. Now, why I use the expression ticklish? Because arbitrariness is not as wide in the context of a subordinate legislation challenge as that of ordinary arbitrariness in other fields. Arbitrariness has been confined to the extent that you have to look into the arbitrariness from the angle that the primary legislation did not confer power to provide for such a provision. That is arbitrariness in the context of challenge to a subordinate legislation. No, it is not that this is arbitrary because you are comparing between black and white. You have to say that the legislation did not confer any power on you to provide for a comparison between black and white. So this arbitrariness, or the sixth facet, is not as wide as the arbitrariness that we understand. Say, for example, in the commercial field, tenders and all that. So, these are the four. I'm sorry, the six fundamental grounds, on which subordinate legislations are challenged. I think, I have to address Your Lordships on the second, third, and sixth aspect. First is, Your Lordship, I will not, multiply decisions on each topic. I'll be as misered as possible. First is, yeah. না ৬/৪ আছে পি কৃষ্ণমূর্তি আগের দিন লাস্ট যেটা বলেছিলাম। আচ্ছা 79(3) দে তাহলে। Milord, only one request, Milord. I'll be very unfair to the court. Milord, I've got a matter fixed at 2 p.m. It's a continuing matter.
First half?
First half.
আরে হ্যাঁ তো 3 নম্বর
এটা কোনটা? 79 তো? But the first judgment, Milord, in the sequence is 2006, 4টা বের করে রাখ, is reported in 1979 volume 3 Supreme Court cases 229. But here, Milord, a regulation, Milord, under the Electricity Act was under challenge. One paragraph from this judgment, which is paragraph 41. The grounds of challenging the validity of subordinate legislation are well known. The challenge may be on the ground that the power to make the law could not have been exercised in the circumstances which were prevailing at the time when it was made, or that a condition precedent to the making of the legislation did not exist, or that the authority which made the order was not competent to do so, or that the order was not made according to the procedure prescribed by law, or that its provisions were outside the scope of the enabling power in the Parent Act, or were otherwise violative of its provisions or of any other existing statute. As it happens, none of these grounds are so and so. Therefore, Millard, in 1979, Millard, the Supreme Court was more concerned about the or confining the challenge to a subordinate legislation more on comparison with the parent legislation. And the situational needs. Now in 2006, Millard, Supreme Court expands the scope of challenge. Please have a look to Millard, this judgment, which is P. Krishnamurthy, which is consistently followed. This P. Krishnamurthy reported in 2006, volume 4, Supreme Court cases 517. Please come to Millard, paragraph 15, 1-5. There is a presumption in favor of constitutionality or validity of a subordinate legislation, and the burden is upon him who attacks it to show that it is invalid. It is also well recognized that a subordinate legislation can be challenged under any of the following grounds. 1. A. Lack of legislative competence to make the subordinate legislation. B. Violation of fundamental rights guaranteed under the Constitution of India. C. Violation of any provisions of the Constitution of India. D. Failure to conform to the statute under which it is made or exceeding the limits of the authority conferred by the Enabling Act. E. Repugnancy to the laws of the land that is in any enactment. And F. Manifest arbitrariness, unreasonableness to the extent where the court might well say that the legislature never intended to give authority to make such rules. Now, this arbitrariness or unreasonableness is confined to only this part. Because arguments are often made that this is arbitrary, this is arbitrary, this is arbitrary. Article 14 is Millard brought in. But in a challenge to a subordinate legislation, Millard, the expressions arbitrariness or unreasonableness does not have its full play. It is connected to what the legislature intended. If the legislature did not intend to provide for prior teaching experience, then of course, Millard, it can be. But Millard, we often have seen, Millard, that prior teaching experience or any other weightage has succeeded in court, Millard. There are innumerable judgments, few of which, Millard, I'll place before my Lord. Then, Millard, this P. Krishnamurthy is consistently followed, but I'll show one judgment, two judgments more only, which is 2000. Next one is 2016, volume 7, Supreme Court cases 703. Please note down the paragraph number only. It again quotes P. Krishnamurthy. Para 34. Nothing much on this. Now, the last judgment in this series is 2022 SCC Online SC 444. Dental Council. Achha, which is also the regular citation is 2022 volume 6 SCC 65. দিয়ে দে। Now, please take me at paragraphs 24 onwards. Here, Millard, the subordinate legislation was quashed. The division bench of the High Court vide judgment has allowed the writ petition and quashed the impugn notification on 3 grounds. 24.1, that it is violative of Article 19(1)(g). 24.2, that is beyond the scope of the powers of the Council to make delegated legislation as provided under the section. 24.3, that it is violative of Article 14 inasmuch as the dental colleges established prior to the impugn notification would be permitted to run without attachment with medical colleges, whereas the dental colleges established after the impugn notification will be compelled to have such an attachment with the medical colleges. We find that the learned judges of the division bench have erred on all counts. It will be relevant to refer to the following observations of the court in Indian Express. A piece of subordinate legislation does not carry the same degree of immunity which is enjoyed by the statute passed by a competent legislature. Subordinate legislation may be questioned on any of the grounds on which plenary legislation is questioned. In addition, it may also be questioned on the ground that it does not conform to the statute under which it is made. It may further be questioned on the ground that it is contrary to some other statute. That is because the subordinate legislation must yield to the plenary legislation. এই আমার কি হচ্ছে বলতো আমার রোজই পাওয়ার চলে যাচ্ছে পাওয়ার চলে যাচ্ছে 10% এটা আনা তো plenary legislation is questioned. In addition, it may also be questioned on the ground that it does not conform to the, I'm sorry, Millard, I missed 1 or 2 lines. It may further be questioned on the ground that it is contrary to some other statute, though it may also be questioned on the ground of unreasonableness. Such unreasonableness should not be in the sense of not being reasonable, but should be in the sense that it is manifestly arbitrary. This is the qualified application. It has further been held by this court in the said case that for challenging the subordinate legislation on the ground of arbitrariness, it can only be done when it is found that it is not in conformity with the statute or that it offends Article 14 of the Constitution. It has further been held that it cannot be done merely on the ground that it is not reasonable or that it has not taken into account relevant circumstances which the court considers relevant. Then, Millard, on the experts field, please take Millard. Then Millard, this Krishnamurti is again considered at para 30. Now, please come to Millard paragraph 41 onwards, where Millard the requirement of the authority is looked into. This court, in unequivocal terms, has held that it would be wholly wrong for the court to substitute its own opinion for that of the legislature or its delegate as to what principle or policy would best serve the objects and purposes of the act. It has been held that it is not permissible for the court to sit in judgment over the wisdom and effectiveness or otherwise of the policy laid down by the regulation making body and declare the regulation to be ultra vires merely on the ground that in the view of the court the impugned provisions will not help to serve the object and purpose of the act. We find that the observations quoted herein above of the division bench of the High Court are totally contrary to the view expressed by this court in so and so. The division bench of the High Court has erred in substituting its wisdom with that of the rule-making body, which is an expert body. In this respect, it will be apposite to refer to the observations of this court in so and so. After considering various judgments on the issue, the court observed The courts are neither equipped nor have the academic or technical background to substitute themselves in place of statutory professional technical bodies and take decisions in academic matters involving standards and quality of technical education. If the courts starts entertaining petitions from individual institutions or students to permit courses of their choice, either for their convenience or to alleviate hardship or to provide better opportunities, or because they think that one course is equal to another without realizing the repercussions on the field of technical education in general, it will lead to chaos in education and deterioration in the standards of education. The role of statutory expert bodies on education and role of courts are well defined by a simple rule. If it is a question of educational policy or an issue involving academic matter, the courts keep their hands off. We are therefore of the considered view that it was not permissible for the division bench of the High Court to enter into an area of experts and hold that the unamended provisions ought to have been preferred over the amended provisions. But somewhat similar submissions are being made. That 2016 rule did not permit or did not provide for prior teaching experience. Then the last paragraph is paragraph 47. I can skip over 47, not that important. Therefore, it's ultimately the requirement of the competent authority or the expert body that has to be given credence. But there can always be a better formula. There can always be a more comprehensive, more compatible procedure or a provision. But that cannot be a ground for entertaining a challenge to a subordinate legislation. So, this is my first limb of submission, that what is the scope of challenge to a subordinate legislation. Second, third, and sixth facets on which I need to address your lordship, because on the first, fourth, and fifth no arguments have been admittedly advanced. But there is a very well written special bench judgment of the Telangana High Court, where for contractual employees, out of 100 marks, 45 marks or 45% marks was awarded to those who are coming from or who had a contractual service experience. Whereas the other persons, or they call it open market candidates, they were deprived of this 45% marks out of 100. Therefore, obviously, it fell for challenge. Initially, it did not succeed. Then, since it was Andhra Pradesh, therefore, after the state got bifurcated, the second batch of writ petitions filed, where the Telangana said that we are not going to follow Andhra Pradesh. Then a third batch of writ petition filed that why not follow Andhra Pradesh rules. Then the matter was referred to the larger bench. In this scenario, the larger bench of the Telangana High Court was considering, but this is a sort of a digest, this judgment. Your Lordship may kindly consider this. This is 2020 SCC Online, Telangana 1073. A longish judgment, but it is considering several judgments of the Supreme Court on several points. May I place hurriedly a few paragraphs on facts. Please take para 1. On so-and-so, a series of writ petitions challenging the grant of, or non-grant of weightage marks to contract employees by the state government or by different power utility companies. Now, my lord, skipping the rest, please take, my lord, paragraph number 2. On so-and-so corporation issued notification for filling up vacancies for the post of sub-engineer, lineman and junior lineman. The notifications prescribed by the selection procedure, that is, out of 100 marks, 45 marks were earmarked for service rendered on contractual basis, thereby leaving only 55 marks for written examination. The grant of maximum of 45 marks as weightage marks depended on the length of service rendered, that is, 2.5 marks would be given for every half year of service as contract worker in the organization. The decision to grant weightage marks was based on a settlement arrived between the managements and such. However, the open market candidates challenged the apportionment of 45 marks as weightage marks to the service rendered on contract basis before this court and in a batch of writ petitions. The petitioners therein contended that no such weightage marks could be given to a group of candidates, for it would make the selection totally one-sided. Hence, the grant of weightage marks was arbitrary and discriminatory. However, by the order of so-and-so, the learned single judge upheld the grant of weightage marks, etc., etc. With the rest of the facts, I've given you, Lordship, brief background of the facts. I will not trouble you, Your Lordship, with those. Now, it was referred to the larger bench because of certain reasons. Now, please take, my lord, paragraph number 20.
Yes.
In the above background, the full bench is required to answer the following issues. Issue number 1, my lord, we are not concerned. Please take issue number 2. As part of the selection process for direct recruitment, whether the employer has the power to apportion marks towards service rendered by a person on temporary basis or not. If yes, whether such power is an enabling power which cannot be claimed as of a right by the employee. To what extent marks for contract service on outsourcing basis can be prescribed out of total marks for the selection. Then, Miller, the cases are categorized. Please take para 21. Under 21, Miller, capital A, Division 1, recruitment in government service. Division B, Division 2 is recruitment to government utility. Under that, category 1, challenge to the constitutional validity of the rule 31 of the so-and-so rules, which vests power in the governor to, oh no, this is relaxation. I skip over this. Please come to category B at the next page. Pertain to challenge the validity of so-and-so issued by so-and-so, by which rule 9 of so-and-so was relaxed and weightage of marks to contract services was prescribed. Then category 3 is denial of weightage. Then, Millard, these are all categories defined. I will not trouble your lordship with those. Now, please come to, Millard, paragraph number 55. First, Millard, the issue is answered. Then, Millard, the reasons. Reasons follow the answer. The answer is paragraph 55. The issue is answered as under. Please take Roman 4 under that, or Roman 3 also. The rule is not unguided or unbridled. Enough safeguards have been provided against arbitrary exercise of power of relaxation. 4. Employees working on contract basis are clearly an identifiable group. Thus, they are a class by themselves. We are pausing here for a moment. My submission would be that the persons with teaching experience are a classified or clearly identifiable group. This would be my submission. In substantive post. And the power to relax so and so, we are not concerned about relaxation. Please skip over 5, then 6. Relaxation of Rule 9B of so and so paves way to compute the contract service for weightage in the process of direct recruitment. That is in the facts of that case. Now, thereafter, Millard, your Lordship may kindly take para 56 onwards. Well, I'll read a few paragraphs, Millard, from here. Before we examine and decide the issues framed herein above, it would be apposite to first delineate the general aspect of selection process, the legal difficulties which arise in the process, and also to deal with the case law on different aspects of selection process. For this discussion would be useful for the final decision about the issues framed and mentioned above. There are certain prerequisites for employment in the state service or in service under the state entities. The eligibility criteria need to be prescribed. Regular recruitment should be made by following the procedure prescribed by the service rules, regulations, bylaws, policy, decisions, circular instructions governing the service. Before commencing the recruitment process, wide publicity indicating the eligibility criteria and procedure for selection need to be given. The selection has to be conducted in a transparent manner. The selection must be in strict compliance of Article 14(16) of the Constitution. Eligibility criteria include educational, professional, technical qualification, experience, age, etc. Procedure of selection may include selection exclusively based on written examination or oral examination, or both, prescribing minimum pass mark in the written examination and or prescribing minimum pass mark or oral examination, shortlisting of candidates for further selection by holding screening tests, prescribing preference based on higher educational qualification, age, experience, etc. Employer can prescribe tests to assess the skill in a particular discipline, such as typing, shorthand, etc. Thus, it is for the employer to custom tailor the eligibility criteria and or selection procedure as per his requirement. The employer is the best person to assess the qualification required to hold a post and method of selection. Every person who possesses, I can skip over for 59, 60, 61. Please take Millard 62. Recruitment to public employment is a perennial source of litigation. It covers a vast range of issues, from appointing on temporary basis to continuing temporary employment for long years, from not resorting to regular recruitment to reservation to social groups, from eligibility criteria to method of selection to illegalities in the selection process, etc. Broadly, there are 4 aspects to employment in public service. Scope of power of the employer to regularize the services of persons employed on daily wage basis, normal master role, employed on consolidated wages, employed on contract basis, employed on outsourcing basis, etc. For brevity, hereinafter broadly classified as temporary employees. 2, assigning preference, where we are here. Assigning preference to a class of person in the selection process for employment. Prescribing a procedure for selection for direct recruitment. Scope of judicial review in matters concerning selection and weightage to temporary service. Then, Millard, please come to para number 76 or 74. But in 74, the heading is assigning preference to a class of persons in the selection process for employment, that is II, and III is prescribing procedure. Employment in the state service, where I skip over Millard 75, not required. Please take 76. 2 fundamental aspects which govern public employment are prescribing eligibility criteria to a post and the transparent procedure of selection. Eligibility criteria include educational qualification, age, experience, etc. Procedure of selection may include selection exclusively based on written examination or oral examination, or both. The employer may prescribe minimum pass mark in the written examination and or prescribe minimum pass mark in the oral examination. The employer may resort to shortlisting of candidates for further selection. By holding screening tests, the employer may also prescribe preference based on higher education qualification, age, experience. So this is accepted. Weightage on experience, amongst others, are accepted, etc. Assigning weightage to service rendered on temporary basis and weightage to seniority in acquiring educational qualification also come under the procedure of selection. Employer may prescribe tests to assess the skill in a particular discipline, such as typing, etc. Thus, it is for the employer to custom tailor the eligibility criteria and/or selection procedure as per his or her requirement. The employer is the best person to assess qualification required to hold a post and the method of selection. Therefore, weightage for experience is sanctioned by law. Then we can skip over Miller 2 paragraphs. Or I can read Miller the last sentence of para 78. This is the right, Miller, which Miller an incumbent applicant has. Please check the last sentence is paragraph 78. In fact, the right is of equal opportunity to compete a right of consideration, but certainly not of appointment. Well known, Miller. I need not, Miller, trouble you with all that. Now, please take Roman 4, Miller, after para 78. Scope of judicial review in matters concerning selection and weightage. Judicial review of administrative action is the core of our constitutional scheme and the rule of law. It is all pervading and encompasses all aspects of executive actions where rights of individuals are affected. However, scope of judicial review in matters touching recruitment to public employment is in a narrow compass. Judicial review on such aspects is confined to whether any malafide stroke arbitrary decision was taken to prescribe a particular qualification only to favor a particular person, not a class. Or persons, and or such qualification do not at all required to hold the concerned post, but is prescribed in order to eliminate a person or persons. That is why, Miller, I wanted to exclude what was not argued. But the argument is not that this prior teaching experience is not required for the post. And this is what, Miller, the full bench says, that the judicial review is available inter alia for prescribing a qualification which is not required for the post, but is prescribed in order to eliminate a person. No argument has been made that according to me, as I have put it in 2 compartments, that the inexperience gets completely eliminated. And if there are illegalities in the selection process, vitiating the selection, this has not happened as yet. As long as the eligibility criteria and the procedure for selection meets the mandate of Article 14, 16 and 309 of the Constitution, and no illegalities are pointed out in the selection process, the scope of judicial review on the qualification prescribed to a post and the procedure for selection is a limited one. Now, the Supreme Court in para 80, I would like to keep it for my future references, is a digest of the Supreme Court judgments. From the precedent decisions of the Honorable Supreme Court on the scope of judicial review in matters of prescribing eligibility criteria, selection procedure, and the right of a candidate seeking public employment, the following principles can be carried out. Article 14 and 16 or 16 of the Constitution neither exclude the laying down of selective tests nor preclude the government from laying down qualification for the post in question. Such qualifications need not be only technical, but they can also be general qualification relating to the suitability of the candidates for the public service as such. State of Mysore, so as well. Suitability of the candidate for the service. I consider an experienced teacher to be more suitable than that of a inexperienced one. Then 2, the court should not usurp the function of determining the appropriate method of selection. So much argument has been made. When should the marks be given for prior teaching experience? At which stage? 2K and 2L. That is why this is important. Court should not usurp the function of determining the appropriate method of selection and the relative weight to be attached to the various tests, even in the case of proven or obvious oblique motive. What would be amounting, that would be amounting to rewriting the rules. The court do not undertake such an exercise. Leeladhar so and so. Matters relating to creation and abolition of post, formation and restructuring of cadres, prescribing the source, mode of recruitment and qualification, prescribing additional and desirable qualification, including grant of preference, criteria of selection fall within the exclusive domain of the employer. The court has no role either in determining the methodology of recruitment or in laying down the criteria of selection. It is the employer who is best suited to decide the requirements that a candidate must possess according to the needs of the employer and the nature of the work. In the garb of judicial review, a court cannot sit in the chair of the appointing authority and decide what is best for the employer. Moreover, the court cannot sit in appeal over the judgment of the employer and ordain a particular that a particular post be filled up in a particular manner. This is what Miller, the petitioners have invited the court to undertake. That the court must direct at what stage should the prior experience marks be awarded, or inviting the court to lay down the manner in which it should be done. The court cannot lay down the conditions of eligibility if the language of the advertisement and the rules are clear. The court cannot sit in judgment over the same. In such matters, the power of judicial review can be exercised only if it is shown that the action of the employer is contrary to any constitutional or statutory provision, or is patently arbitrary, or is vitiated due to malevolence. It is also not open to the court to make comparative evaluation of the merit of the candidates. That stage has not come. Court cannot suggest the manner in which the employer should structure or restructure the cadre. We are not concerned about that. Next, 4. Since the administrative authorities have experience in administration, the court must respect this. Thus, the court should not interfere readily with administrative decisions. The court should not ordinarily interfere with policy decisions unless there is a clear violation of some constitutional or statutory provision or the statute. There should be judicial restraint in administrative decisions. An enabling provision postulates a discretion which may or may not be exercised. The court cannot find fault in exercising an enabling power in a particular manner. Where the executive action of the state is challenged, the court will tread with caution and not overstep its limit. The interference by the court is warranted only when there are oblique motives or there is miscarriage of justice. The recruitment notification merely amounts to an invitation to the qualified candidates to apply for recruitment. On their selection, they do not acquire indefeasible right to the post, even if all the vacancies notified are not filled up. In service jurisprudence, constitutional court should balance the equality principle with the principle of classification. Dependent on the nexus for making the classification, this aspect is best left to the wisdom of the administrative authorities. But pausing here for a moment, as I have initially submitted 2 or 3 minutes, I have submitted sometimes back, that this is not a pure service matter simpliciter. My lord, in the context of deciding the validity of the rules, has to take into consideration, I won't say has to, needs to take into consideration what is the purpose. The purpose inter alia is to also provide for better education, for whom these persons would be, or the intending candidates would be selected. Therefore, that has to be kept into mind. That is it a simple comparison between 5 candidates who have offered their candidature, or is it a consideration amongst 5 candidates who can serve the best or who can provide better quality service for those for whom they are intended to be appointed.
The nexus to be.
Yes, this is the nexus. Therefore, the nexus for making the classification is also very important. Apart from classifying between group A and group B, the nexus is that according to the legislature, persons with better qualification or persons in group A can serve better, persons in group A can provide quality service or education, whatever. Therefore, this is the nexus. Apart from whether weightage preference can be granted or not, the underlying important aspect of the matter is the nexus that these persons or persons with this qualification can serve better or provide better services. Because now we need to also keep in mind that Article 21A has come. Then, Millard, I was in 8. 9. In the mode of selection, if the mode of selection is not prescribed by the rules, and there is no other impediment in law, it is permissible for the competent authority to lay down the norms for selection, such as holding test, minimum benchmark, and written test, as well as viva voce. Paragraph so and so. 10. If classification is otherwise legal, valid, and reasonable, it is not prohibited by Article 14. Because so much of the arguments were made on 14 and 16. I say, Millard, this classification is otherwise valid, has a nexus, weightage is permitted in law, preference is permitted in law, and therefore, Millard, the legislation or the subordinate legislation cannot be faulted. Then, Millard, para 81. Para 81, Millard, is the conspectus of whatever was discussed above. From the above precedential case law on all the 4 aspects, it is thus safe to conclude that we are not concerned about A, please take B. In the process of direct recruitment, it is open to the employer to permit temporary employees and not governed by the directions in para 53 of Uma Devi to compete in regular recruitment by relaxing age regulation and by assigning weightage to such service. Then 3, C, it is for the employer to prescribe procedure of selection for direct recruitment to public employment. While D, while prescribing procedure for selection, it is permissible for the employer to apportion marks for temporary service, seniority, so and so. This E, the scope of judicial review in matters of prescribing qualification, procedure of selection, and method of selection is very limited. The writ court cannot act as a court of appeal and cannot determine what qualifications can be prescribed to hold a post. It cannot prescribe the procedure of selection to make regular recruitment. Only when there is a patent illegality in the selection procedure process would the writ court interfere. Well, we are not, I mean, the challenge is not to the selection procedure or process. The challenge is, number one, prescription of prior teaching experience, and when should it be given?
No, the other challenge is whether the prior teaching experience marks can be allotted only to the state government teachers. There are central government teachers, there are private school
Right.
teachers, aided, non-aided, lots.
But
The classification.
that classification, Supreme Court has upheld that you can discriminate.
We'll come to that later on.
Which is called, as per the Supreme Court's words, valid discrimination. But here, Millard, the Supreme Court, Millard, distinguishes between an invalid discrimination and a valid discrimination. I'll come to those. There's a Rajasthan
Judgment has been placed.
Yes.
All right, we'll see that.
Then, Millard, paragraph number 82, guided by the above principles, so and so. Then I need not trouble your lordship with the middle paragraph. Now, please come to para 99. This is a classic case where below 10 marks extra for a particular college. Kindly see. In Sanjay so-and-so, challenge was made to clause 3 of chapter so-and-so. Selection was based on written examination. In the process of determination of merit for selection to post-graduation courses, 10 marks were assigned to students who had graduated from Rohtak Medical College. Therefore, one particular college gets precedence. It was urged that due to assignment often additional marks, the graduates of Rohtak Medical College were pushed up in the merit list. Though this decision concerns admission to postgraduate medical courses, but the basis of challenge is the same as urged in the present set of writ petitions, namely challenge to the grant of weightage mark. However, the apex court repelled the contention of discrimination and of offending Article 14 of the Constitution of India, para such and such. So even in a case where out of 10,000 colleges, students of one particular college gets an advantage, will not upheld. Then please take me to the next one, that is para 100. Consistently, the Honorable Supreme Court has upheld the power, but if your lordship requires me, I can place these judgments, but
No, it's not required.
that will make it very long. Consistently, the Honorable Supreme Court has upheld the power of the employer to assign weightage to temporary service rendered by a person and to grant age relaxation while making regular recruitment. Then please come to Miller paragraph 113. Conclusions on this issue, 113. But please take the last 3 lines of that page. If employer requires. If employer requires a cook, he may prescribe cooking experience more than educational qualification. For a particular post, the employer may give more weightage to experience than to higher qualification, higher educational qualification. For certain posts, say class 4 posts, employer may prohibit persons with higher qualification. Thus, depending on the requirement of a job, appropriate qualification eligibility criteria may be prescribed. It is the prerogative of the employer. The judicial review cannot be stretched to oversee what qualification, eligibility criteria, and the mode of selection should be prescribed by the employer. In the present cases, admittedly, there is a large pool of employees having basic qualification who have undergone processes of selection, have rendered considerable service, and have gained experience in the core aspects of the job for which recruitment process is being taken up. Experience gained by them is certainly useful for the employer. The employer may thus prefer a person with experience over a raw person. Therefore, preferring a person with experience on the same job neither amounts to bias nor to arbitrary exercise of power. It is a classification based on intelligible criteria, that is experience on the same job versus inexperience. So it's a choice between experience and inexperience. Que the purpose, the ultimate purpose. But here, of course, the Supreme Court, the Telangana High Court was not considering the purpose or the other aspect. Then please take me, Lord, weightage, 118. Thus, grant of weightage marks is legally permissible. Hence, the arguments raised by the Learned Counsel against the grant of weightage marks are clearly untenable, hence unacceptable. Issue number 3. Whether such power is an enabling power which cannot be sought as a right. Ancillary to these issues are 2 more questions. A, whether employer, the state, or its instrumentality is under obligation to extend the scheme of weightage to temporary service rendered outside its employment or not. And B, whether not extending the benefit of weightage marks to those outside the employment of the power utility companies would offend Article 14 and 16 of the Constitution. But then para 123(1), Millard, are examples of selective weightage, Millard. But kindly permit me to come back on the next day.
Could you finish up with this judgment and
Well, I have to read
more paragraphs?
at least 10 to 12 other more paragraphs. That's why I said, well, this is a digest. I'll keep it, Milord, for my future references.
All right. Ready? The learned AG commences argument, but does not conclude the same. When would you like to come back?
But I can come back on Monday or next Tuesday also. Today we are on
10th.
Tuesday.
10th, next Tuesday.
Very good.
10 তারিখ।
Oh. 9th.
কি হয়েছে? ক্যান টুটা নেই।
But in this matter, I was added later on, and Lordships granted me to use an opposition also. So
You want to file it?
It is identical. It is same thing, but still.
The opposition দিচ্ছে একটু দেখে নিন। Please file it.
Weekend একবার আসিস।
How many? How many? One means in volumes.
There are volumes of the SLPs and others. There's nothing new, and these are already.
Why add up documents which are not relevant or copies are there?
Because this is not going to.
And affidavit in opposition filed by, check up by who? And in 4 volumes. Please write that. No, he'll be getting all copies to be circulated.
You are the main person.
Certainly copy will be given.
Several affidavit filed by some of the copy I get,
You write letters so that the copies can be given.
There is no difficulty.
Please write to the advocates for furnishing copies.
It is very much difficult to follow the who process of which matter he get that.
You have the affidavit, the application for addition of parties. From there you can trade.
Everyone not get that.
Application for addition of party also not given.
Some of the person, I will give it some.
Mala, this is a.
Any applicant who has not served copy, please serve copy upon the writ petitioner.
Affidavit গুলো follow করো, লিখে রাখো। Copy দাও। Copy দাও।
Did you serve the application? Not the opposition, the application you served.
I was already added as part.
The court added parties even though applications were not served with the direction to serve. And thereafter, these are not served. See, this is a submission that is being made.
Copy দিয়েছো দেখাও।
Item number 21 can I
এটা দিয়েছো affidavit দিয়েছো?
না আমাদের কপি
প্রদীপ,
দিয়েছো?
Can 5
কাকে?
বলছে allow হয়ে গেছে but it is still
Juniors.
if the opposition.
Oh, that's a different matter.
Hey, item 22, opposition, 21. 21, opposition filed by the which respondent? Clash applicant in can 5. It will be open for the petitioner to file reply if required. Otherwise, so many applications are there.
After filing all this, I will use a consolidated reply. Otherwise, it is very difficult to follow each and everyone's affidavit.
Anything else?
But we are yet to receive the copy of amended cost title after addition of parties.
The applicants are being added on daily basis. So we still do not have an amended cost title.
In process.
Uday Shankar Chattopadhyay, Shuman Shankar Chattopadhyay, or Pranoy Basak over here? Any of them? No. Petitioner in Bhim Sarkar is you. Did these advocates file any application? Can 6?
Can 6, yes. The last occasion, Malala, remember that.
Huh.
Last occasion, Mr. Uday Shankar Chatterjee will make submission thereafter. Probably memory.
Disallow the cancel.
Disallow. And Malala, I believe they preferred an
Appeal. আচ্ছা Chattopadhyay, so that at 2 o'clock, right? This was mentioned. I do not know what is the reason.
mention.
It has been mentioned.
Correction.
এগুলো একটু ঠিক করে দিতে হবে। এটাকে রাখুন, দুটোর সময় আসবে তখন কথা বলে নেব। Item 19 is being heard, and with 2021 opposition file 22, 23, 24.
Up to 24.
Opposition
24.
filed in 19 also.
Yes.
And that opposition is for can number 3 added respondents.
লিখে নেবেন কিন্তু। All right. So we'll start from 25. তাই তো? You mentioned this matter for correction. What is the correction?
Correction is, my lord, your lordship on that day, 6th January, my lord, your lordship, after hearing my evidence in opposition, my lord, first scan was allowed earlier day. But on that day, after hearing evidence in opposition, your lordship first an elaborate order, my lord, that order not in the server. This is my contention, my prayer.
That order is not in the server.
No, my lord. The de novo examination, you file the
একটু দেখবেন তো
petition.
একটু দেখবে what is the date of the order?
6th January.
6 January.
That portion, because there are so many, my lord, that there are so many orders passed, my lord. That is in the, my lord, also in the, my lord, record YouTube, my lord. That order your lordship.
All right, I'll check up. There, then it will be put up. একটু দেখে নেবেন তো অর্ডারটা এখানে তো নেই। পরে দেখবেন আগে লিস্টটা রাখুন।
The time for the petition. This is the exception to the report. This is the exception to the report. This is regarding the model question answer key mismatch. My lord, my stand at the very first instance, I say that, my lord, my stand is not to draw your lordship's attention to the questions, answers, this, that, because law is well settled. That court will not sit over the appeal of the expert committee. But the Honorable Supreme Court, in several judgments, including our High Court Honorable Division Bench, as well as to absolutely similar matter of Rajasthan High Court and Madras High Court, everywhere the law is same. That when there is such discrepancy, which is demonstrable, visible, and can be supported by the text, then matter is to be referred before the independent expert body. That is my stand before your lordship today. I would not ask your lordship and request your lordship to kindly verify which one is correct, which one is incorrect. To that effect, my lord, we have prepared this compilation of judgment. Which
compilation of judgment?
Because it shows, I will not take much time, only few paragraphs. This clearly says that the law has been given. What is the law today? My lord, need not to get into the issue. Only send it to the expert committee to decide whether I am correct or no. Why I make this submission? Rule 11. If your lordship kindly takes Rule 11 for once.
An expert has already checked the answer, isn't it?
After that, because why I tell you, lordship, Rule 11, there are 3 elements. First element is that I can raise objection besides suggestion. 2 words are used, suggestion stroke objection. So both have been used separately. When there is an objection, the requirement is that I have to give 2 authentic academic records with PDF. I do that. I pay money for that. So it's 100 rupees each question. Now, Section 11 says that it is to be dealt by the expert committee. Now, my lord, when there is an objection, when Rule 11 is asking for supporting material records, it is duty incumbent, the statutory duty upon the
Where
expert.
is the requirement of production of 2 support?
Yes, kindly take Rule 11.
Study materials and something.
Rule 11. Rule 11 of the recruitment rules. Kindly take 11.5, Roman 5. May place before lordship. Roman 5, the Central Commission shall publish in its official website preliminary model answer keys after the written test and may invite suggestions and or objections from the applicants. Provided that suggestions or objections must be submitted within 5 days after publication of such model answer keys and should be supported by at least 2 authentic academic publications. Next, the Central Commission shall form a subject-wise expert committee comprising not less than 2 members in the rank, not lower than professor of college, university. The expert committee shall deal with suggestions, objections. Now, my lord, there are 3 elements. My respect.
Show me their
yes.
report.
Yes. Kindly take their report. The last page, page 10, the annexure. I have objection regarding 2 questions. I am short of 1 mark to qualify. My lord, kindly take this first 1 to 22 answers are unchanged with original master key. I have no objection. Do not fall within 1 to 22. 23 question itself is wrong and out of syllabus. They give a reason for change. They give a reason. I don't follow.
Which one?
Next
Which
one is mine.
question?
Mine is 27 and 42. So I come under 24 to 47. They say answer are unchanged with original master key. No reason assigned. Merely saying answer is unchanged. My respectful submission before your lordship today is
All right.
when you are changing, you are giving reasons. When you are not changing, you are simply saying that it is unchanged. You are not considering 2 academic records. You are not dealing with what the statutory interpretation of dealing with is, that you have to exercise your mind. You have to say why 2 authentic academic records I am relying is not correct. You have to come up with that.
All right.
Now, my lord, I have one more submission, my lord. I will not take much time of from this report. I can show your lordship. Kindly take page 6 of the report. Page 6. Kindly take page 6. Your lordship has seen. This is the grievance details. Kindly take 27, which is my question, master key wise. Your lordship will find 2,928 objections were raised against one single question. So I do not come as a stray person with one objection that is not correct. 2,928. Everybody has given their objections with supporting materials. Now, my lord, kindly see.
And what is your submission that the question is wrong or out of syllabus?
My submission is this. The question number 1 is
27.
Yes, 27. My question is correct answer will be D and not C.
That means the change in the...
No, now there is one difference here. They say they accept question is wrong or out of syllabus. There are 6 grounds under which the wrong
Challenge
can be considered. I will show that. So they do not go by my challenge. There is no consideration of my challenge that you have to take D, not C. They say question is wrong or out of syllabus. Why? They have given the reason in the report. The majority of objections say the question is wrong or out of syllabus. But in the rule, it has never stated that you have to take the majority objections.
No, that is how can you take that?
They,
Alright,
they
that's all
cannot.
right.
Yes. Now, my lord, kindly take 42. That is also my question. 42, my lord, your lordship will find 975 objections. And the nature is question is wrong or out of syllabus. But I had stated that the question, the manner it has been printed, it is Sanskrit. It's a very technical subject. The manner it has been printed, merely there is a gap between 2 words, the meaning gets changed.
All right.
And the answer also accordingly changes, which I can show from my writ petition how I have explained it. My learned friend has taken a point that I have changed my objection in the writ petition, saying that the petitioner suggested that the question is wrong or out of syllabus, and objection has been changed in writ petitioner, says that the correct answer will be C and A. Because I could not say this in the objection because there is no such scope for writing. It is preset objections in the drop down box. In 6 counts I cannot say that, see, the word is wrongly printed in your question paper. I cannot say. So I had to click in the nearest objection I could get. Now, my lord, kindly take page number 8. So my objection is also not there, has been considered. They have taken the majority, which is not there. Now, kindly page 8. These are the 6 grounds. So they are duty bound to consider my objection under these 6 grounds. But my objection has not fallen within this. They have not dealt it in this. Have not. Now, my lord, so far the law is concerned, it is very specific. My lord, I have found absolutely similar and identical issues. Same expert committee was appointed. There was a provision for objection. The court has category, very recent judgments of Rajasthan High Court and Madras High Court. They have said that no, when you have come up with substantive material records, it has to be checked by the independent body. Now, my lord, Honorable Supreme Court has categorically stated that when there is such objection raised, it is the duty incumbent. Yes, I admit to the extent, my lord, the Honorable Writ Court is not a fact-finding body. Honorable Writ Court is not the expert body. Honorable Writ Court will not sit over the appeal of the expert committee. I admit and concede to that. I will not make one objection to that. But when I am able to show from material records that my answer is also correct, it is the duty incumbent upon to be sent before the commission.
All right,
Now,
let me hear once. Commission. Is anybody online? No? All right.
Yesterday, similar matters were adjourned, citing pendency of MAT
30.
30.
MAT 30 is my matter. Questions are different. Not all issues are same. Over there were two different questions. Which are of
that matter.
Yes, it's my matter only.
We have produced the compilations also of judgments.
All right.
In fact, if that issue will not, let us understand it very clearly, subject to what falls from your lordship. If your lordship is persuaded to hold that yes, the court may direct this, that issue is your lordship rejected the prayer.
Please hear what the court has to say, then you make submission.
And that matter, my lord, it is different. There are two separate questions because
all right, wait.
And there is no stay of your lordship's order.
The report that you filed, the chart, it is not paginated, right? After page 5, so it will be page 6.
I have paginated this one.
20 doesn't matter. 27 question number. How have you dealt with? 27 and 42.
42. Master key number.
How have you dealt with? You have merely said that the answers are unchanged with original master key, right? Now the rules have been placed which mentions that you are to deal with it. Does the word deal mean only giving one line, that the answer remains unchanged when the candidate has supplied two authenticated academic publications?
Authenticated,
This is your language. The court has not used it. Now, if you say that no, it is not authenticated, it can be. I do not accept it because it is not authenticated. It can be a mode of dealing it. But how have you dealt with? It's too mechanical.
I don't think, I do not know, I may be incorrect. This report of the SSC perhaps has not been dealt with by my learned friend.
Yes, an exception has been filed today.
Given to Mr. Singh, I can give you a copy also.
It has been filed.
Exception that is the standing instruction that I have to send to Mr. Singh. I have dealt with. That is just one reference model. That is the authentic copy. That is the ISBN, ISSN number books and text materials. Instead of authenticated, authentic books.
Whatever.
Yes.
How have you dealt with?
Whatever is there in the report, I cannot improve on anything beyond this. Not in the other matter. The commission has been directed to use an affidavit now. If your lordship wants us to file a detailed affidavit, we can file a detailed affidavit. Pardon me for saying this. Yesterday also I made this submission. What the Supreme Court is saying, this domain has to be left on the experts. One.
Do it, but let the expert act in accordance with the act and the rules.
Now,
more than this.
Provided there is a contemporaneous finding that the expert has refrained from doing so.
The expert, you see, what will you say? The answer remains unchanged. The law requires that the decision of the expert committee shall deal with the suggestions, objections. How has it been dealt with? Apropos the objection made, how has the expert committee dealt with the objection? Nothing more.
Then we'll use an affidavit.
My lord, there is no scope for development in this matter. I don't know what.
Let the matter be argued, my lord. I believe, my lord, let my learned friend.
Learned friend has been submitted. There is nothing to develop.
My lord, let us, my lord, argue it once for all. Let it be decided. The
Exception.
matter is pending, my lord, consideration in the
Just
honorable division
submitted,
bench.
there is nothing to develop.
No, exception to the
Then
report
again,
by the
affidavit.
petitioner to the except
No, no,
by
আগে
the
তো
petitioner to the report
কালকে যখন
filed
অন্য
by the commission
জনের মামলা অ্যাডজন্ট হচ্ছিল তখন
is
তো
taken
তোমার
on
গ্রাউন্ডে
record.
ছিলে, তোমার গ্রাউন্ডেই তো অ্যাডজন্ট
I
হচ্ছিল।
don't know. If they can't
Yes,
make submission, I can't take the responsibility.
That doesn't prove that you can make submission.
learned advocate
I
for
can
the
make
petitioner
আমরা তো
referred
কিছুই জানি না, কিন্তু এটা
11
তো ঠিক না।
within brackets
There is nothing new to submit.
small v
You cannot
5
develop. Then what is the
and
affidavit to
6
be developed?
vi of the West Bengal School Service Commission bracket open selection for appointment to the posts of assistant teachers for upper primary level of classes. এটা এখান থেকে কপি করবেন, হ্যাঁ। Third bracket, except work education and physical education. Bracket close, comma.
কি my lord is
Classes
quoting a rule, my lord, on the basis of which no examination has taken place.
এই রুলটা
9 and 10. And classes 11 and 12.
আমাদের রুলটা
Comma rules 2025. Stop. The wherein, comma the wherein there is a wherein the central committee is required to publish in its official website preliminary model answer keys after the written test and may invite suggestions and / objections from the applicants. Stop. The suggestions / objections are to be submitted within 5 days after publication of such model answer keys, supported by at least 2 authentic academic publications. Stop. The petitioner objected to TWO2. প্রথমে TO তারপর TWO. 2 questions. Stop. The expert committee dealt with the suggestions / objections. No, dealt with no. The expert committee opined that the answers to the subject questions remain unchanged with the original master key. Stop paragraph. Submission of the petitioner is that the expert committee ought to deal with the suggestion / objections and not merely make a remark that the answer remains unchanged. Stop. Paragraph. The
order decision making processটাকে আমাদেরকে show করতে বলা হয়েছিল, that is not even given in the report. The full discussion is not, it's been a full elaborate discussion after which it has been arrived at, this decision has been arrived.
learned advocate representing the commission submits that the expert committee considered the objection filed by the petitioner and accepted some of them.
It is deemed.
The recommendation of the expert committee is final and binding in terms of Rule 11 within bracket VI. Stop. The petitioner is trying to re-evaluate the answer script, which is impermissible. Stop. Next. From the report filed by the commission, it is not very clear as to how the academic publications relied upon by the petitioner as to whether the academic publications filed by the petitioner were considered or not. Stop. The mode of consideration of the academic publications relied upon by the petitioners shall be placed by the commission before the court by way of an affidavit.
No, my lord, after your lordship complete the order, my lord, will indicate something, my lord. It is a part of the report already.
Show me.
Yes. Please. Please come to the. My lord, kindly comes. Kindly takes the report. My lord, this is how we have dealt with it. My lord, kindly comes to paragraph 3 onwards.
I have checked up paragraph 3 onwards.
Yes.
You have not mentioned anything about the publications.
Well, about the, there are, on any given subject, there might be 10.
Maybe 20 also. How does it matter?
That is, experts will not consider.
2 because your rule requires 2.
Experts will not particularly give emphasis on a particular book.
Rule.
Kindly seize the rule. Kindly seize. Please see, I read in my own subject. It is stated that paragraph 4.
From the report.
Of the report.
You show me from the rule how the expert dealt with the academic publications, nothing more.
Paragraph 5, we have stated.
Yes.
As per Rule 11.6, the Commission invited experts in the field of Sanskrit to form an expert committee. The expert committee was headed by a professor in the Department of Sanskrit. The experts invited were kind enough to accept such invitations, and the expert met on this. The Commission provided the compilation of grievances and objections received by all the applicants, syllabus of Sanskrit, question paper, and the preliminary answer key to the experts for their review of the preliminary answer key of the Sanskrit PG, and for dealing with the objections raised to 50 questions by different candidates, including the petitioners herein, the identities of the expert, etc. Then
nothing is mentioned.
Then the expert committee met on this, and they deliberated upon the various objections, including upon a detailed. The expert committee found objections with respect to 4 questions to be valid and suggested appropriate changes. In fact, the expert committee found one of the objections made by the petitioner in respect of question number 36, series C, corresponding to question number 60 of master code, to be correct, and as suggested by the suggested appropriate changes. All the changes suggested by the expert committee were duly incorporated by the commission in the final answer key. The signature of the expert have been marked, and then we have annexed it at annexure C. No,
This
please.
is the last one page handwritten which you have relied upon in respect of all the objections.
This
that
is
have come.
yes. Yes.
How the experts have dealt with the academic publications.
My lord, kindly come to page 8 for once. My lord, kindly take page 8 for once. I can show one thing in respect of paragraph 5. Kindly see. My learned page 8. Kindly see. My learned
Page 8, the handwritten portion.
no. I am showing. My learned friend has submitted page paragraph 5, where the annexure is paragraph B. So he's relying upon paragraph B, and according to my learned friend, they have considered the objections. Now kindly take page 8. 8 at the very bottom. What are the documents placed before the expert committee? The book question booklet, the preliminary answer key, and the syllabus are being attached with this mail for your kind perusal and preparation in advance. There is no whisper of the records.
Study material.
Yes, it is not correct. With
No, my lord,
deepest respect.
this is the
Never
final
considered.
recommendation of the expert. My lord, my lord, certain things are beyond the purview of even, my lord, the writ petitioner. It is not his domain as to how the experts have come to a particular conclusion.
Sir,
1 to
just
11.
tell me how the
But
expert.
if your lordship, if your lord, my lord, this is something very internal. My lord, what weighed with the experts, how they have considered it.
Did the
That may
expert consider at
yes.
show me?
But that,
Show
my
me.
lord, we can if it.
Mention anything over here?
This is the final recommendation. Again, I am saying.
No, the report.
This is the final thing. What your lordship is looking at page, whatever minute this page is, page 10, this handwritten portion is the final recommendation. Deliberation.
We can produce it before the court.
That will be, we'll be producing it in a sealed cover for your lordship.
What sealed cover?
But that cannot be, that weightage. This is beyond, he is inviting your lordship to travel.
No. The petitioner has relied upon certain books. You say it is not authentic.
I am not saying anything. The
expert. It is the expert.
They have considered it.
Yes, the expert will say, no, this is incorrect. This is not authentic. Let them say something that yes, this study material was considered. The court will end over there. The court will not traverse beyond that. Ki bollam?
There is no consideration. They have to say why those documents are not correct even.
আচ্ছা বলতে দে বলুন ঠিক বলুন বাচ্চা বলছেন আমরা করে দেব
Read book B, students 3 will read book C. Just সব বই consider করতে হবে নাকি?
By
Everybody is reading different books. There are hundreds and thousands of books.
There were 2928 objections. If 2928% suggest books, they may not.
Why did you frame? Why was such a rule framed? There was no requirement of submitting objections with
to become more
transparent.
We have in fact here are one of his questions. He is not saying that.
There are 5-6 books.
He is not saying that.
I have recorded in the order. He is not saying I saw your affidavit and I recorded that you have corrected one of the answers.
The domain that your lordship is being invited to travel to, is perhaps beyond the scope of a writ petition. Kindly pardon us.
Achha.
There are 5-6 books, ISSBN number, we have followed that. Everywhere same answer is given.
24th of February. Released 10th of March.
10th of March.
My lord, my
In the meantime, check up what happens to the appeal.
Yes. My interest will be protected in case I come successful, my lord.
Obviously, it goes without saying. It is recorded the candidature of the petitioner shall abide by the result
If he
of
gets a chance, he gets a chance.
gets
Will he
a
wait for
chance.
the outcome of the writ petition? I don't think so.
Obviously not.
Of course, I'm
No,
1 mark short.
He has not reached the cutoff only.
1 mark short I am only.
There are so many candidates.
Yes. And my lord, so far the book, next occasion I will be submitting. My lord, so far the books are concerned, it is the ISSBN number. These books are taught in the classes, which I have relied upon. They cannot say this book is wrong. They have to come up that I'm not accepting this book. They have to come up with that. 26 also similar, my lord. It is subject nutrition. একটা second.
How many questions?
6 questions. এর স্বরূপের ভেতরে ঢোকাও। This is my exception to the report. এই হার্ড কপি দেবো বিশুদ্ধা হার্ড কপি দেবো এটা রেখে দাও hard copy.
Scan করে ঢুকিয়ে দিয়েছি।
Which question?
Yes, my lord, kindly take questions number 2. Your lordship is referring to the page, it is not paginated. The question number 2, master key 2, 13, 17, 40, 42, 52. It is in the first annexure of the report given by the commission. And your lordship will find in similar manner it has been dealt with.
How many questions have you objected? 6 questions.
Kindly see the objection. Kindly take the first. In question number 2, 571 objections. In question number 13, 134 objections. 17, 115 objections. 48, 67 objections. 42, 275, 52, 839 objections.
48, question 48.
No, question 42.
42,
13, 17, 40, 42, 52.
2,
13,
13,
17,
17,
40,
40,
42,
yes.
52. These are the master key numbers I'm giving. Now, my lord,
And you
time-
did not object to 18.
Lordship?
1923 objections.
Yes, kindly see. No, I did not. I do not.
You did not object.
I did not object to that.
All right.
My lord, kindly come to the last annexure.
Yes.
Your lordship, this is even worse.
3.
2 is not there.
3.
2 is not there, my lord. 2 I objected is not there. 13 is not there. 17 is not there. 40, 42, 42 is only there. 40 is also not there. 42 they say the question is not properly.
কি মুখ বের হোসেন হচ্ছে?
Option A may also be correct.
Option A may also be considered in addition to option B.
Option B. So they are not even sure what should be the answer. Now, my lord, 42 is there. 40 is also not there. 52 is also not there. Kindly take the last line. The answer for rest of the questions which were
Referred to remains unchanged.
There has to be a reason why it is unchanged. Why you are not considering these academic materials? So many objections. Not I have come up with the objections. It has to come up with the same logic I'm relying upon.
Question numbers গুলো কি আগেরটাতে বলেছিলাম?
Check it পরে কি 34, 35.
বলিনি না? এখানে লিখুন ওই কি দিয়ে শুরু করেছিলাম ওখানে? হ্যাঁ, এক্সেপশনটা টেকেন অন রেকর্ড। তারপর হচ্ছে
সেটা দেখতে হবে স্বরূপ চক্রবর্তী।
And here your lordship is looking at a petition of 24 petitioners. There is also 24 petitioners. This it is very extremely difficult. Yesterday I objected, to one of the writ petitions.
And
98.
possibly all the petitioners
They did not object to single questions.
Produce similar study material.
Similar study material. Those
all same study material.
Not all 24 have been agreed by 6 questions. My lord, they have given the study material. These are
out of
these are all common study materials which are studied by all the candidates. These are available books. All IS.
Let them file 24 petitions.
Maybe some candidate whose answers were found to be correct read other books, or
no, these are similar in all books. My lord, suppose the question is very simple.
Out of 24 petitioners, 20 have raised objection.
No.
Out of 24 petitioners, 20 have made objections for different questions. And milord, what I find from records that milord, against milord one question there were 12 petitioners, against one question there were 19 petitioners. And milord, every document, every issue cannot be the same.
If the marks
So milord, there is milord, as I was submitting before your lordship yesterday, there is no homogeneity. It cannot be a milord.
Who are the candidates who did not file any objection at all?
Milord, it just gives me.
Writ petition shall be dismissed in respect of them.
Kindly appreciates, my lord. If the question is correct, my lord, kindly do not deprive them of their marks.
If the question is correct and if answer is given, then he will also get marks.
Yes, so kindly do not dismiss them, my lord, at
No,
this
what
stage.
to do?
No, and not at this stage, my lord. Not at this stage. If your lordship finally holds it, very well, no problem. Not at this stage. Let it be decided, my lord.
First, you tell me without raising an objection, how can the writ petition be filed?
No, possibly all of them have.
He has used the report. In paragraph 2 of our report, we have indicated that. Paragraph 2.
The numbers.
Paragraph 2.
This is the exception.
Yes, this is, please see his exception.
তুমি তো এখানে বলোনি।
They have raised questions against 6 questions before this honorable court, but at the preliminary stage, all the petitioners raised different objections. In fact, out of 24 petitioners who have approached this court, only 19 raised objections in terms of Rule 11(5). The remaining 5 petitioners have no right to institute the writ petition by piggybacking on the 19 others.
You write on the others. Rely upon
Not
the
my
others.
language, Milord.
I did not
Whoever.
want to speak backing. I did not.
Yes. So, how will the 5 maintain the writ petition?
Yes, my lord. Yeah. My lord, if ultimately it is found the questions are my contentions are correct, my lord, let them not be deprived of the benefit, because if it is wrong for all, right for all.
Right. So if it is found to be right, your objection in respect of A,
19.
the benefit will go to the rest also. It is not that it will be restricted only to
Those who have
you.
come before the court, those who have accepted it, they have chosen not to come before the court. They are not interested to get the marks. I am interested, my lord. I have come. I have lost this battle, my lord. That is why I have come. They are not interested.
No, but then the law requires
that is
to apply within a
yes, my
particular
lord, that is
time.
a procedural mechanism, my lord. Kindly appreciate that.
All right, I'll take care of.
Yes,
The
and
rest
the-
can be deleted or dismissed or whatever. But
not
then how has the study materials been considered? The court wants to know this only. Otherwise, nothing. And moreover, see, page 11, whether at all these objections were considered or not is also not very sure. The answer to rest of the questions is referred remains unchanged. It's so very mechanical. Where is the
Well,
application
these
of
persons
mind?
are not under our employment also.
Nobody
We
is
have
saying
invited
so.
them. They have responded to our call.
Nobody is saying so. But
We
when-
can't control them.
When
They are
the
academicians.
experts, they are acting in accordance with certain rules. It's not that they are doing it without
Just
any
for the sake of it.
It's the career of so many candidates. Can you understand what is going to happen if the experts deal with the objections in such a manner when your law requires the experts to deal it? They should have been aware of how the suggestions and the objections are required to be dealt with.
Your lordship is looking at the summary of the review.
Yes. See, the questions which the petitioner objected to, there is no mention. So it will go by the default clause type of.
Miscellaneous. It is.
Answer to the rest of the questions which are referred remains unchanged. Whether at all
Similar matters have not been entertained by your lord.
Yes, I understand. But as and when submissions are made,
Wait for sending before the expert committee, let it be decided by the expert committee. That would be the right.
No, my instruction is petitioner numbers 12, 13, 14, 15, 16. 5 petitioners did not raise any objection.
Check, I have to check, I have to check.
Right, that will be taken care of. It will be taken care of. Just show me.
Well, let it be dismissed for them, because those persons, first
It
of
will
all,
be
they
dismissed.
cannot come together in one writ petition.
It will be dismissed for them.
And in any event, the remaining 19 also cannot come together. They have different causes of action.
839 objections, 839 petitions will come before your lordship.
Cannot help.
That is a difficulty.
If
It becomes easier for everyone to respond also.
Suppose there is objection to one question by everybody, then at least we can take it well.
There are such candidates. There are
Other candidates.
Mixed bag candidates.
Why? Why will this be there? It becomes difficult for the respondents to respond.
Commission has resolved this issue by giving their chart and the answers. If it is not considered for anybody. If not considered for
I have followed it.
him, not for her.
This is what the stand of the commission is piggybacking. This is exactly what
I
is
understand, but
piggybacking.
it has been resolved by now. They have given their stand.
Petitioners have হ্যাঁ ওটা থাকবে। হুম ঠিক আছে, ওটা হলো। তারপর সেটা হয়ে গেছে। তারপর হুম ইয়েস, এইখানে লিখুন পিটিশনার্স objected to question numbers
Yes, question numbers, my lord. Question numbers of
2
master series, kindly mention.
acha of master series 2,
2. Yes.
master series 2,
13.
13, 17, 40, 42, 52. Rest same type way. ডাইরেকশনও একই হবে। আর একটা যেখানে কমিশনের বক্তব্য বলা হচ্ছে এখানে একটা প্যারাগ্রাফ অ্যাড আপ করবেন যে দি learned advocate for the commission raises an issue with regard to the maintainability of the writ petition at the instance of 24 petitioners. Stop. It has been mentioned that 5 petitioners have not raised any objection, and accordingly they do not have any right to institute the writ petition. ঠিক আছে, একটা লাইন অ্যাড করবেন, the issue of maintainability of the writ petition is left open. Yes, call the next one.
34 and 35 also same point. The lordship can.
Which one?
34 and 35.
Please wait, I'll go one by one.
এটা কবে রাখবেন না?
Same day 10th.
The Lordship has been kind enough to keep it, Milord.
10ই March.
10th of March. But within 3 weeks, a report by way of an affidavit has been directed to be filed.
1 week for me.
1 week for
1
you.
week for me.
What is this matter?
Lordship, we are the assistant teachers of a recognized school. And
Recognized by whom?
I am led by Mr. HON'BLE.
Recognized by whom?
Recognized by Minority Educational Institutional Act, my lord. And
Recognized by?
recognized by Lordship. Recognized by West Bengal School Education Department, my lord.
All right.
And our school was recognized in the on 1/5/2001, my lord. And subsequently, we were the assistant teachers, and when the notification for second SLST exam came, we applied for that. We applied, and there, my lord, the teacher code was not available, and we cannot provide that, the teacher code. The 10 marks, we could not get that 10.
All right. Now show me how much marks you have got. Where are the results? Have you gone through the brief? Why are you looking back?
But,
Your brief is there in your hand. See, at the junior stage, facts should be there in your fingertips. For law point, you can come prepared. Facts, you should know in which page the fact is there. You cannot look behind for your senior to prompt you where the fact is mentioned. Each and every document annexed to the writ petition, you should know. All right. Yes. Where is the result? How many marks short?
My lord, one candidate, Sanpui, na? Sanpui result is লাগানো। Huh.
10 marks for total.
One of the candidates, page 99,
Yes.
Ramesh Shapui, he has been able to qualify.
All right.
Other two, they have not been able to qualify.
Other two means there are four
There are four. Other three,
not been able to qualify.
No.
Short of how many marks?
short of since I don't have the exact quantification
Oh,
of
the
how many marks that they
quantification
have.
is out.
My lord,
Quantification is out.
I
Result declared.
since I have not, this was filed prior to that. So therefore, my lord, we have not been able to, my lord, we didn't have the occasion to, my lord, quantify as to what was my result and subsequently what is. My result has not been, my lord, since I have not been able to qualify, results have not been, my lord, annexed.
See the preliminary interview list you have annexed.
Yes.
It must be there.
Yes, yes. The marks which have been obtained,
Not prepared. Come prepared.
just two marks, but this was at the time of filing of the writ petition, it was not there.
Anyway,
My lord,
it is annexed to the writ petition.
No, only one person who has, my lord, qualified, I have annexed. But the point is that we were not given the chance even to, my lord, opt. Lordship, my lord, the recognition has been placed before the lordship of the school. May I just, my lord, show two
No, see the
pages?
10-mark issue is already pending.
No, May
my
I
lord, this
just
is not the
tell your
10 mark
lordship two things. First is, none of the petitioners have indicated their experience in the application.
No. We could not. That is my point.
And similar matter dismissed by your lordship.
No, my lord.
Yes,
But kindly, my lord, may I just?
No,
we are
it is
working
not
in a
the dismissal to the fact.
dismissal might be. It's not a similar matter. My lord, the
How do you know whether it's similar or not?
my lord, I have, my lord,
Are you aware which order he is referring
my
to?
lord, he must be referring to that 10 marks order, my lord, which
I am
10
referring
marks issue
to.
is pending.
I am referring to this.
Past.
Please see this. My
Not
lord,
prepared.
This is Jahar Navodaya Vidyalaya. This is a different thing. IMS recognized.
What was the consideration, Anindo? Please, don't be so unreasonable.
না জহরটা আমি জানি খুদই তো করছি
Come on next day, 9th.
দিয়ে দিলাম order.
9th. Next.
But Jawar was a different matter, my lord, altogether. But kindly keep it tomorrow, my lord, I'll come with
হ্যাঁ, কালকে আমি
Ninth.
নেই। কালকে ভাই নেই।
9th. Call 29.
পূর্ণিমা সরকার। পূর্ণিমা সরকার। দুজন petitioner।
My lord, I am for the petitioner, my lord.
Yes.
Kindly seize your lordship last order dated 19th of January. Here, my lord, they have filed their report. Well, we have filed their our exception also, my lord. Last occasion I have submitted, my lord. The lordship direction was to revert back with instruction. Here, my lord, preliminary question, preliminary answer key, my lord, supports my answer. In the final answer key, my lord, they have changed. And we are shortfall for only 1 mark. Our contention before your lordship is that
We means how many are there?
well, more than 40.
40. Everybody
My lord, 5 or 6
misses
persons have been.
the cutoff by
I
1.
have mentioned in paragraph 4, my lord, 5 of 6 petitioners have managed to qualify the cutoff score, but rest, my lord, falling short for 1 mark only.
Yes.
And in the preliminary answer key, my lord,
See, anybody falling short of 1 mark or 2 mark, if they approach the court,
6.
then the how can the selection process be concluded?
My lord, your lordship kindly visualize the situation. Well, the preliminary answer key supports my answer. My lord. The preliminary answer key, my lord, they have.
I don't know where from the commission has got hold of the experts who
Yes.
differ with the marks provided by the examiners.
Because the paper setter is also an expert. My lord, according to the paper setter,
Expected to be.
yes. And thereafter, my lord, after the objection was raised by so many candidates, my lord, they said in their report that they have engaged some
You
other
come
expert.
with the English translations and everything here also.
This matter, my lord, they have not objected. They have filed their report. We have filed our objection. Last occasion, my lord, your lordship heard me and directed them to revert back with the instructions. Because in my exception, my lord, I have annexed the book also taught in class 8, endorsed by the West Bengal Board of Secondary Education, which support my contention. I have annexed the documents by international organization, which prepares this endangered list, my lord. Everything is in my favor, my lord.
Only one question.
Only one question.
Which subject is this?
My lord, geography, class 11 and 12, geography.
And in their report, my lord, they have said that several candidates raised objections, 139 objections, and all of them had stated that 2 options are correct. I have not raised objections since my answer was correct. But the objections who have raised the objections, well, they have also stated that 2 options are correct. But they changed it to option B instead of B and D.
1 minute. Is it question number 37?
37, my lord. Page
Booklet
50.
series C. Do you have anything to say, Commission?
Stand by our report, my lord, as indicated in paragraph 3 in the box.
Acha, please come.
Well, I think Mr. Singh wanted to say something in this particular matter. Yeah, Achay?
Milord, with the leave of my learned senior, Milord, may I place one fact? Milord, IUCN Milord published.
Now, your audio is honorable.
Your sound is breaking, Mr. Singh.
And in the report, my lord, they have stated that my information is outdated, my lord, whereby I have annexed the book of 2025 edition also, my lord, in that published in the December 2025.
It is mentioned it is outdated.
Yes, in the report, they have mentioned that
Am I
it is
audible?
outdated information.
Where is it?
Milord, am I audible?
Yes.
Milord, the IUCN list, Milord, of 2008 and 2024 will indicate the answer which is suggested by the petitioners. But Milord, the Environmental Ministry as well as the IUCN list of 2025 will indicate that Asiatic lions population has grown substantially, and that is why it has been downgraded. Milord, since the book was indicated, Milord, we took this onus to research, Milord. In 2025, Milord, there are several articles, Milord, we can place that IUCN, as per the IUCN list, as per the government of India, it has not
Sir,
been.
the court is not concerned which is the updated list, the outdated list. I have got nothing to do. I am not. I am not inclined to go into all these things. Tell me, in that case, the person who checked the answer script first at the preliminary stage, did he not take into consideration the updated study material?
Milord, that is why, Milord, then a scope for review is there in the list, Milord, and that is from a professor of better repute, Milord. It's a
Why
professor.
do you engage persons who do not have updated information to correct the answer script and open up all these things?
Milord, today, Milord, our answer has some basis.
Today
Milord.
and
If our
tomorrow, I
answer
do not know.
Milord, if it can be shown that our answer has some basis, Your Lordship, Milord, we kindly lean in our favor, in the favor of the experts' recommendation. Milord, that's what my learned senior was submitting in the other matter as well, Milord.
And what will happen to the initial examiner who examined at the preliminary answer? He should be sent back to school for
That has been
updating
changed.
himself.
The rules do not provide for any punishment for providing a wrong answer to the initial examiner. But that is why the provision
It
of
is
review
not a
is there.
question of punishing, right? It is not the examiner's examination. It is the examination of the candidates, that is for sure. But then thing is, if the outdated study material is being taught in school, who is responsible? And it is these candidates who are going to teach the students.
Candidates should be aware, Milord. In our law books also, in our law books also, we have taught VAT and sales tax in 2020 when I was studying from 2015 to 2020. Well, VAT was repealed.
I have followed it. uh,
The
how
teachers
do
used to
you-
tell us that this act has been repealed.
how do you answer to what Mr. Singh is saying?
Let him place any record showing that my answer is incorrect. He only stated that it is outdated. I have annexed the documents stating that this is the current position. Because the IUCN survey was last held in 2024. Thereafter, it has not been held. What he is
It
referring
is not for the court to enter into a fight
Well,
as
let it
to
be-
who has the updated information. It is impossible.
Well, kindly visualize
On
one
May
situation. Well,
22nd,
in September
2025,
2025, they have published the preliminary answer key. In November 2025, they have published the final answer key. In between them, they have changed 8 answers.
Yes.
So they are saying our answer is outdated. What about the
All
experts?
it outdated. It cannot be.
In case of this question, my lord, what about the paper setter who said who prepared the question booklet and prepared the preliminary answer key?
Yes.
Because if the paper setter and the preliminary answer key goes in my favor and the supported documents I am relying upon before your lordship is goes my favor, my lord, they have to show something counter to that to prove their case.
লিখুন তো যে the petitioner participated in second SLST, 2025. Stop. আচ্ছা petitioners হবে, huh? They object to question number 37 of booklet series C.
We have not raised an objection because the preliminary answer key supports us.
আচ্ছা none.
None.
আচ্ছা the petitioners কি বললাম, they participated, তাই তো, SLST. Stop. When the preliminary answer key was published, comma, the petitioners found that question number 37 in booklet series C were answered by them was found to be correct. Stop. At the time of publication of the final answer key, comma, the option got changed. Stop. The petitioner did not have any scope to file objection after publication of the final answer. Stop. Paragraph. According to the report filed by the commission, comma, 139 candidates objected to the subject question, and majority of them suggested that more than one answer is correct. Stop. According to the expert, according to the preliminary answer key, option D is correct, and according to the expert committee, option C is correct. Stop. In support of the expert, comma, for answering the subject question, comma, referred to the updated report of the Ministry of, which ministry?
IUCN's report, my lord. It's published by
IUCN.
the same report which is relied upon by the petitioner.
IUCL.
CN.
Union for Conservation of Nature.
IUCN. IUCN. Nation.
My lord, which says that Asiatic lion is in vulnerable status now.
ঠিক আছে? Stop. What is the date of this updation? Can you please say?
You know, on 22nd May 2025, there are some newspaper reports by when Indian government announced it. An IUCN report, my lord, was published in 2025.
Is it within the time period of the difference between the preliminary and the final answer key?
No. The government of India announced it on May 2025, long before the exam took place.
Yes. IUCN report published by the Government of India in May 2025.
IUCN report.
The IUCN report is not published by the Government of India. It's a different body.
There are only articles.
কি বললাম তাহলে ওটা? Published, Government of India কেটে দিন, published in May 2025. ঠিক আছে? Stop.
Well, I have stated in my paragraph also, my lord. Your lordship can consider paragraph 8.
Learned advocate for the petitioners contend that the answers provided by them are supported by authenticate study materials. Stop. Where is your study material? Let me see. When was it updated?
December 2025, my lord. I have annexed in the exception.
December 2025.
Page 13. Page 14 is the, my lord.
The 2024 report, my lord.
No, I am referring to the book.
Book.
This is the original book, my lord.
No, I don't want to see the original.
Page 15, my lord, bottom.
Page 15, bottom.
ভারতবর্ষে এরকম কতগুলি বিশেষ বিপন্ন প্রাণী হলো, এশিয়াটিক লায়ন। My response to Mr. Singh's submission, IUCN has not published anything after 2024. What he is referring to is a news article that I have stated in my exception also. The next survey which the IUCN is going to organize is in the year 2026, this year only.
But in the news article, the same body is saying that it's a vulnerable species, not endangered anymore.
কি বললাম? Taught by the West Bengal Board of Secondary Education. Taught in the schools under the West Bengal Board of Secondary Education. Stop. Next. The court, paragraph the court not being an expert body is not in a position to ascertain the proper answer to the subject question. Stop. The Commission has already relied upon an expert to arrive at a proper answer. Stop. The Commission is directed to revert to the expert with the study material annexed by the petitioners in the exception.
And the petition also, ma'am.
Exception and the writ petition.
Applies.
To ascertain as to whether both the answers semicolon, 1 given at the preliminary answer key stage, and the final answer key stage can be taken to be correct. 10th of March.
Obliged. I'm deeply obliged.
30.
Lord, I'm appearing for the petitioner. Lord, I've taken instruction from the petitioner and she wants to withdraw the case.
Where is the written instruction? Please show.
She informed me 2 hours ago by phone call.
What is your name?
Devjit Dutt.
Are you the advocate on record?
Lord, he's another junior of our senior.
Where is he?
He didn't come to court today.
You better obtain a written instruction from your client and file it. Because if your client at a later point of time denies that she did not ask you to withdraw it, then you will fall in trouble. Do not do that. Obtain a written instruction from her and file it. I'll dismiss the matter. When can you obtain it? By tomorrow?
By tomorrow. Lord. Give us a 7 days time.
Monday.
You've got oral instruction, and to obtain this written instruction, you need 7 days time.
I don't know where she lives or she can contact.
Monday রাখো এর মধ্যে নিয়ে নাও
Wherever the lady lives, obtain a WhatsApp instruction also, which you can file in court. All right, learned advocate appearing for the petitioner, onar appearance ta record korben. Submits that the petitioner has given oral instruction to the advocate on record to withdraw the writ petition. Stop. Paragraph. Released on 9th February. Let written instruction by the petitioner be placed on record on the adjourned date. Next.
31 will appear for the state. Petitioner
I am appealing for this service.
second SLST 2025 Malar for the post of assistant teacher in class 9 and 10 Malar. The grievance of the petitioner is that the petitioner inadvertently did not mention the marks obtained by the petitioner in postgraduate level in her online application Malar. Thereafter immediately I moved the writ application before this honorable court.
Thereafter petitioner moved. All
the writ
right,
application. This honorable court directed the commission to take a decision upon giving opportunity of hearing to the petitioner. Thereafter, since no step was being taken, I filed this writ petition,
Yes.
Meantime, they have issued the communication, dated 31st October 2025, which is a part of supplementary affidavit, they have stated that as a since at the very final stage of process selection process, for that reason they are not in a position.
Possible for the commission to make any alteration.
But on the last occasion, it was submitted on behalf of the commission that an opportunity was granted to the candidate to edit the online application with regard to updating the marks in respect of postgraduate level. That's why Malad was pleased to record the submission and pleased to direct the commission to obtain instruction. And
But then possibly this option was not open.
Yes, Malad.
It was not open. It was only the caste category
Yes,
and
Malad.
everything.
Yes,
But
Malad.
not the
And-
marks.
Yes, Malad. And immediately after the written examination, I approached this honorable court, Malad. It is not at the later stage, Malad.
Immediately after?
Malad, immediately after the written examination, much prior to the publication of result, Malad, I moved the writ application before this honorable court. It is not at the belated stage, Malad. On 14th October, Malad, I moved the writ application before this honorable court, Malad. But if the
Petition was filed on 1st of December.
No, my lord. Prior writ petition which was filed before the honorable vacation bench, my lord.
All right.
Page 48, my lord.
Vacation bench.
My lord, if I get the my marks of the postgraduate level is taken into consideration, my lord, I will be getting, my lord, additional 2 marks, my lord. And if I get only 1 marks, my lord, I will be
There is a matter pending before the division bench.
Which one?
Change of marks. Marks.
That is in respect of 11, 12, my lord. That is this is in respect of 19.
No, but then the issue
But
is
the change of issue is same.
right.
Issue is same.
Same.
Issue is same.
So I adjourn it for the time being. All right. So the petitioner participated in it.
No, my lord, I'm sorry that that matter relates to experience marks.
Oh. No. Here it is the wrong recording of marks in the application form.
No, wrong recording and wrong. He has
Petitioner
given the
himself has declared wrong.
right, wrong. That is, my lord, kindly see the page 4 of the supplementary. The reasoned order.
Yes, I have seen the reasoned order. In the
That's
morning,
right.
one matter was taken up. You were there, isn't it? Similar matter, postgraduate
In the
marks.
morning, yes, sir. In the morning. In the morning, yes.
Right.
Mr. Samim.
That has been adjourned.
That
Due
has
to
been adjourned.
pendency of the appeal or something
Yes,
of
yes.
that sort.
That's
So let this also be adjourned. The petitioner participated in second SLST 2025. Stop. Inadvertently, she did not disclose marks obtained by her in the postgraduate qualification. PG.
Postgraduate level.
Postgraduate qualification. Stop. It is submitted that if the marks obtained by the petitioner in the postgraduate stage is added, then the petitioner will reach the cutoff marks. Stop. The prayer of the petitioner for editing her marks in the postgraduate level stood rejected by the commission by passing a reasoned order on 31st October/3rd November 2025. Stop. The petitioner is aggrieved by the same. Stop paragraph. It appears that the issue as to whether editing can be done after last date of filing the application is pending consideration before the Honorable Division Bench. Stop. In view of the above, hearing of the instant writ petition stands adjourned. Stop. Released on 10th of March.
Yes. Master.
It will be same as 25,
25.
26, you say?
Could be.
How many questions did you object to?
The questions are two. Two questions. I've given that option B is a more appropriate answer than options in the first question. And the next question, both options A and B are correct, and not only option B. These are the two counts, my lord. And if you
Question number,
Yeah,
there is
yes.
a box in the
Yeah.
report of the
question number
option.
page 2 of this is not paginated. My lord, kindly come to the first first annexure of the report, except report, my lord. Grievance details. Question, kindly come to the next page. That is page question number 35 and 50 in the master key number 35 and 50. 616 objections. Question is wrong or out of syllabus, that has been taken. My objection has not been considered.
And 50.
50. 183 objections, more than one answer is correct. That is taken. That is taken. I had said that both options A and B are correct, and not only option B. That was my objection. They take that more than one answer is correct, but ultimately it comes with nothing. The result becomes, they say there is no change. Kindly take their the annexure C, my lord, the second last page. of the
Question number 50.
kindly take 19 to 36. Your lordship will find 35 within that.
Answers are correct as per the
Answers
answer key
are correct
uploaded
as
on
per the
the
answer key
website.
uploaded on the commission's website. That's all. No deliberation, no dealing with, no considering the material records, nothing. Merely saying that it is similar.
Objection was that more than one answer is correct, but this has not been accepted.
Not only that, my objection has also not been considered because that is the majority objections which was taken, though it is not there in the statute.
Maybe.
Yes. The simplicity they say that application answer are correct as per the answer key uploaded. No reasoning is there, no dealing with, no consideration of the material records, academic records, authentic academic records. Similar to the next page, my lord. Same in stereotype, this is same answer are correct as per the answer key uploaded on the commission's website. No reasoning, nothing as per rule 11, no dealing with, no consideration of the academic records.
Option given in the answer is grammatically incorrect. Which subject is this?
This is English.
English.
Kindly take for once the repetition. Page number page number 8.
No, I'm not going to look at the question or the answer.
Very well. Number 7 I stated as per the model answer. Key the option C. Real freedom has been given as the right answer.
26. An order has been recorded. Change the question numbers. Which series is this?
No, kindly take the master key. Master key is equal for all.
Master key?
Master key 35 question.
Master key 35.
Yes, and 50.
Master key 35 and 50. 50.
It would be easier to consider in the master key.
Just change the question numbers. The order remains the same. 26.
All right. I am appealing on behalf of statement.
All the
Appearing for this. I am appearing for this.
Yes. 35 is also same.
35 is English. That number of this is my exception. Well, kindly record that I have given the exceptions are being taken on record.
It is there in the earlier order, so it goes down in this order also.
Report petition.
No, today he's filing.
Raised objection. All of them have raised.
Let me see. 35, what is the which question did you object?
Yes, my lord. There are total 3 questions. Objection raised. That is Master Series 50. Your lordship will find from the first annexure of the report.
Expert report.
58.
Question 58.
Question. Well, I'm giving serially, my lord. It has not been given serially. 40. No.
Question 40.
58. 56. 56,
40, 56 and 58.
58.
Question numbers change. 40, 56 and 58. Rest of it remains the same.
Only one objection kindly, my lord, from my side.
Yes, please.
That's the expert final opinion is binding on a court.
Yes, yes.
And
I have recorded that in the order.
And this court cannot, my lord, go into the reasoning of the expert.
All
Kindly
right.
record.
I have recorded this in the order.
Okay.
Yes, 36.
Grateful to Lord. Much obliged.
36.
36 की number.
36.
My lord, I am for the SSC.
Right.
My lord, according to the instruction from my senior,
the opposite parties were directed to server report.
Report. Where is the order? There is no order. I don't see any order. To revert with instruction. Representing the commission to revert with instruction, not a report. What is your case? Please place.
The petitioner appeared in second state level selection for assistant teachers, which was held on 14 September 2015, 2025. And the petitioner obtained marks of 57.
What is the cutoff?
Cutoff was, my lord, 58.
1 mark short.
And my lord, the answer key that was given, there were several questions which were wrongly added, and the petitioner is expected to receive marks based on that. Marks for them, the wrongly added questions.
Did you raise any objection at the preliminary stage?
No, my lord, no.
Was the answer of the petitioner correct at the preliminary stage? Not ready?
No, my lord,
Why? Yesterday you were there or day before yesterday?
No, my lord, I wasn't there. My senior was.
You took adjournment, isn't it, in this matter?
Yes, my lord.
Why are you not prepared today?
I didn't have the file, my lord.
You didn't have the file?
My lord.
Not even the soft copy?
No.
Why don't you keep soft copies? So that you can prepare yourself in case your senior is not available. Come prepared. 9th, I'll take it.
Yes, my lord.
Don't call any other matter.
Kindly take it, my lord, kindly take it on 11th. 11th.
Most of the matters are fixed on the 9th.
But 9th, some difficulties are there.
No, no, tomorrow, Mr. My senior will also not be in difficulty.
When? Tomorrow?
Tomorrow. Kindly do not take next 2 days. He will be also
Let
in
us
some
see.
difficulty.
Let us see how I can prepare the list so that the other matters are also
Yes, yes.
accommodated.
My lord, can I suggest to you, subject to your lordship's permission, instead of tomorrow, keep it on Friday, and this matter also keep it on Friday.
Let us see. Let us see.
টানা বুঝছিল নাকি